Good morning, good afternoon, everyone. I welcome you all to our fourth workshop series, Perspective on IBC. And as you all are aware that we are celebrating International Women's Week, our today's speaker is Ma'am Prachi Wazalwar, ma'am. Ma'am, I welcome you on the behalf of ICSI and IIP. I would briefly introduce ma'am. Ma'am is a qualified advocate. She is a corporate lawyer. She is qualified company secretary and has done her LLM from University of Pune. She specializes in corporate litigation, including corporate insolvency matters, operation and management matters, winding up matters, resolution, mergers and amalgamation. She has also handled wide variety of commercial contracts and national and international arbitration and handles numerous corporate cases before the Honorable Supreme Court, High Court, and other tribunals. Ma'am has handled around 300 plus cases related to IBC and over than 1,000 cases under Companies Act as well. Ma'am, today I welcome you on this platform. And before we begin with the session, I would request ma'am to share some of her journey on this special week of Women's Day celebration. If she could share some of her experience in the field.
Sure. Firstly, good afternoon to all the participants. I thank ICSI IIP for inviting me to this session, especially in the Women's Week, because it's a long journey as an advocate and as a company secretary. I can say that from the time that I started, say that was in 2009, some 15 years back, when I started in legal field, I had hardly seen women. There were hardly women who were appearing in the courts who were litigating. But today, if somebody just presses the link of IC, and entire NCLT is online, so perhaps NCLT at least people can witness that women have now come a long way since then. Earlier, it was considered litigation or law per se was considered to be a man's world. And many a times, even when I started, many people told me, "Oh, litigation is not for women." And out of in Bombay High Court, there was only one women senior counsel, only one woman who was a senior counsel. Rest all were men. So it was a man's world. And but over time, since the last 15 years, women have been introduced in the legal field and several other fields. It is really nice that you have started this series, you have started this program, a women's special program. And as regards my journey, I would like to say that I don't see a difference between man and woman, and the it doesn't matter. It is ultimately everyone today is striving and struggling. Just that when it comes to a woman, she has to deal with various aspects, because at home she is asked, there's certain responsibility which everybody takes it for granted that she has to do. Then otherwise in business, in work, in the profession also there are, but I profession also you have to balance that balance. Sometimes a woman has to do more than a man, but otherwise I feel that even the courts today are not creating that distinction, which is good. That glass ceiling which is there in the corporate sector is not there in litigation and in NCLT. Especially, you will see women are also appearing here. Women are resolution professionals. They are getting similar treatment. The court is not giving a priority to a woman, but at the same time, they are getting an equal status. They are getting same type of respect from the courtrooms also. So, with this, let us start today's program on
Sure, ma'am.
NCLT.
So today, ma'am will be dealing with the topic of drafting, pleading, and arguments before NCLAT and NCLT. Ma'am, you may begin with the session. And in case there are any questions among the participants, they can raise their hand or put it them in the chat box, and then it will be dealt simultaneously.
Okay, sure.
Thank you.
I would like to just start my screen sharing. Just give me 1 minute.
Sure.
Ma'am, from ICSI,
Yes.
you have not mentioned your name basically, so I cannot address you with your name. So
Okay.
actually, we have not got PPT for the last program, ma'am. So
Yes,
please ensure.
sir,
Yeah.
I am yet to receive it. I have not received it from the
Okay,
speaker.
I've just noticed
No,
before
no,
you.
no issues. I will definitely send it. I'll follow up with the speaker today and I'll share it with everyone.
Yeah. Are you able to see my screen?
Yes, ma'am, it's
Yes,
visible.
yes.
Yes. Okay.
Yes, ma'am.
Okay. Just 1 second. Yeah. Are you able to see the screen?
Yes, ma'am.
Yeah. All right.
You can make it full screen.
Yes, yes, but because I have to show you other
Yeah,
slides also, so let me
no
just
issue.
all right now?
Yes, ma'am.
Yeah. So I'll just give a brief introduction about myself. I'm Advocate Prachi Wazalwar. I practice in NCLT, and this is a very interesting topic that we have taken today: drafting, pleading, and arguments in NCLT and NCLAT. I think all of you must have sometime or the other appeared in NCLT. Am I right in assuming that?
Yes, yes.
Yes, okay. So, with respect to me, I have been a company secretary and thereafter I became an advocate because I wanted to practice in all the courts. So, NCLT, when it was constituted in June 2016, that was the time, since that time, and before that, CLB and High Court, we were appearing there. And in NCLT, we started appearing since June 2016. So we have in fact seen the entire journey of how the IBC has evolved from December 2016 till today. Okay, so what I want to do today is I will be taking up drafting, pleading, and arguments in NCLT, NCLAT. While doing that, I am not going into the details of any IBC provisions because I think all of you are well aware of that. What I want to do is I want to take up this issue and show you how the drafting is done or what type of thought process goes behind drafting a particular petition. So therefore, what we will do is we'll do a hands-on approach where we will see a petition and we will see what are the things that we need to consider while preparing the petition. Because either you will be preparing certain drafts, for instance, a Section 7 petition or a Section 9 petition, you yourself may draft it, or else what you will do, you'll give it to an advocate and thereafter you will see whether it is all right. Or in other cases, we say, for instance, you are drafting a progress report or else which now has to be given in the form of an I. So what all things you need to know as a as a resolution professional or as a liquidator, that those are the things that we will see. Okay, so let us first start understanding what is to be done with respect to NCLT. What is the holistic perspective behind NCLT, NCLAT? All right. So whenever you are thinking about, say, appearance or starting practice in NCLT, okay, or you are going to file anything in NCLT, first you have to understand jurisdiction. We will go into the drafting of it, but before that, we have to understand 2 to 3 important things. We have to understand jurisdiction, we have to understand limitation, we have to understand the general procedures which are there. Without that, going into a particular act and drafting it will not help. Okay, so that overall perspective you should have with respect to what exactly is NCLT. So therefore, we will start with jurisdiction. Before that, I will just, I think all of you know that, but I will just show you this particular PPT on basics of NCLT because I think you already know about it, but just to ensure. Yeah. So you are aware that in enforcement machinery, there is NCLT, NCLAT, right? In tribunals, there are judicial members and technical members. Judicial members are generally high court judges, district judges. Just to give you a brief background, I think this already everybody knows, but I am just giving you an overview that today there are 16 NCLTs. They have judicial and technical members. Generally, when a bench in any NCLT sits, there is one judicial member and one technical member who sits in any NCLT. So, judicial members are generally high court judges. At times, they are judges who have a ITAT background. Then there are certain judges who have been DRT judges. So that way, some are advocates. So that kind of judicial members are appointed. Some are high court judges, some have come from district court. In terms of technical judges, we have certain judges who are chartered accountants. We have certain judges who have some experience with the government, for instance ICLS officers. And this we will see later on, that what is the significance of understanding this, because the kind of questions that you will face as a RP or as a liquidator will depend on the background of the members and what kind of questions they can ask you. So that also you should be prepared. So you should know what kind of questions you will be faced with. Okay, so therefore you need to understand that which is the bench you are appearing before, what is the background, and what are the kind of questions that they ask, where especially when you are appearing in person before any tribunals. Even if you have a lawyer, you should be prepared, because in NCLT they generally ask either the liquidator or the RP to remain present in person. Many a times they ask questions directly to the resolution professional. So as you as a RP or a liquidator have to be prepared to answer the question which are raised by the judges. So this is an overview of NCLT. So NCLT, any person who is aggrieved with an order of NCLT has to go to NCLAT. Any person who is aggrieved by an order of NCLAT has to go to Supreme Court. So this is the general hierarchy with respect to NCLT. Yes. So let us start with drafting, pleading, and arguments. Yes. So now let us take an example that there is a Section 7 petition that you have to draft and file. Okay, somebody has come to you for drafting of a Section 7 petition. So firstly, what is the important thing that you should know? Section 7, the form, those all are essential. But along with that, you will also need to know the jurisdiction. So what will be the jurisdiction in this particular case? How do you understand the jurisdiction? Firstly, you will have to understand the territorial jurisdiction. For instance, if you get a matter of where the corporate debtor is in Chhattisgarh, where will you file the application? So this is the question that you will have to first answer, that where do I file this Section 7 petition, which courtroom? Okay. So what is the answer? So earlier, I'll just give you an example that earlier Chhattisgarh used to come to Ahmedabad bench. Madhya Pradesh and Chhattisgarh used to come in Ahmedabad bench, but thereafter a separate bench was constituted in Cuttack. If you see the last entry, entry 12, Cuttack, Chhattisgarh. So now this application, Section 7 petition will not go to Ahmedabad, it will go to Chhattisgarh. Okay, so therefore jurisdiction, knowing the jurisdiction is most important. Many a times some people ask me that look, the entire matter has taken place, for instance Section 7. Generally many people who have a civil court background, they ask for such questions that look, the transaction, everything has happened in Delhi, so can we file an application in Delhi? The answer is no. You can file an application under Section 7 only where the registered office of the corporate debtor is situated. So this is the first question. Jurisdiction is the first question any person will have to answer. Again, now this question becomes very important even in case of personal guarantors. Personal guarantors, again, you will have to see where is the territorial jurisdiction. For instance, we had a matter, a Section 95 petition of a person against whom who was a director in two companies. Both the companies were in different NCLTs. One was in NCLT Ahmedabad and one was in NCLT Mumbai. So there was company A and company B. So in company A, the jurisdiction, company A, the NCLT proceedings against that company was going on in NCLT Mumbai. Another company, company B, their proceedings were going in Ahmedabad. So the question was that if you want to file a Section 95 petition against a personal guarantor, which courtroom will you go to? So this is also the kind of questions that you as an RP will have to face. So where do you file? Any answers? Anybody wants to answer this question before we move ahead, or should I continue?
I mean, is the address of the personal guarantor is relevant in this case?
All right, I'll just give you an example. The personal guarantor is from Mumbai.
Ma'am, then the register office will play. I don't remember. I studied for the exam that wherever the company's register office is there, that jurisdiction will come in case of CARP.
Yes. So so that kind of questions you will face. Okay. That especially in case of personal guarantor, right now the jurisdiction is a complete mystery for certain people. So let me just explain why this jurisdiction is important. Because if you file it in the wrong jurisdiction, your matter is going to get dismissed, and you're going to be back to square one. And then the banker are generally, they have little patience. So therefore, jurisdiction, even if on face of it, it seems to be a minor issue, really it is a very important issue that you have to answer. Okay. So the answer to this is that you are completely right to say that the law provides that if proceedings are going on against them, and I'll come to the new laws with respect to NCLT, where they say even if there is no proceeding, you can still file and all that. But currently, the understanding is if the CIRP proceedings or the proceedings and the liquidation are going on against a corporate debtor, then against that corporate debtor, you can file the personal guarantor petition in the NCLT, which is seized with the matter. Okay. So right now, if there is company A and company B, and the personal guarantor is a personal guarantor to company A and company B, you should first see who has come to you, which banker has come to you with respect to the personal guarantor matter. Okay. So you will have to ask, say, bank A. One bank has come to you, you have to ask the banker that you have given a personal guarantee with respect to, they have given you a personal guarantee with respect to which company. So if they say, no, we have given guarantee for company A, then as he is a director of company A and companies A proceedings say are going on in Mumbai, so you can file your Section 95 in Mumbai. Okay. That is number one. If he says that yes, company A was in CIRP, then it was in liquidation. However, now this company is dissolved and there is no proceeding pending in NCLT, you will say, look, you cannot file it in NCLT. You have to go to DRT, because the law says that when the proceedings are pending in NCLT, you will file the petition in NCLT, which deals with the corporate debtor's perspective, or else you will go to DRT. Got it?
Very.
Yeah. Second, if they say no, bank, say for instance, we take an example, SBI says I have given they have given me personal guarantees for company A also and company B also, and both the companies I have only put in liquidation. One is in Ahmedabad, one is in Mumbai. So what? So now there are two courts which have jurisdiction under Section 95. And what does the law on section on personal guarantor say? The law says that if one proceeding is filed, then other proceedings are under Section 96. There is an interim moratorium, right? So what you will do is you can file either in Ahmedabad. If you file Ahmedabad, give the personal guarantee, the guarantees and everything. You have to attach the personal guarantees, what they have given. Attach the personal guarantees of Ahmedabad court. You don't have to file 295 petitions, one in Ahmedabad and one in Mumbai. You file, say for instance, an NCLT. If you are comfortable with Ahmedabad, you file it in Ahmedabad. If you are comfortable with Mumbai, you file it in Mumbai. If you are filing a petition in Mumbai, you can say, look, Mr. This personal guarantor is a personal guarantor for company A, which is in Mumbai. These are the guarantees which has been given for the Mumbai company. Because the proceedings are pending in NCLT Mumbai, I have filed it in Mumbai. You don't have to refer to Ahmedabad, because once a 95 petition is admitted and RP is placed, once the RP report is in place and the proceedings against them under insolvency start, then all the claims have to be compiled. So after that, the banker can file their claim with respect to other claims that they have. For instance, the personal guarantee amounts for other companies. But right now you have to focus what is the jurisdiction. If you put both, there will be confusion. Your matter will get they will erase some or the other technical difficulty, and your matter will continue to remain pending. So therefore, though jurisdiction as such is a very technically a very small issue, but it can have a lot of ramifications. All
Can I
right?
raise one clarification here,
Yes,
ma'am?
please. Go ahead.
What you have said till now, I can what I come out of it is, if there are two companies in which one particular person has given personal guarantee,
Yes,
and if I have to file a case, I should file a case with one NCLT,
yes.
and the claim for the other personal guarantee given to other company will be filed by the banker in that particular NCLT, isn't it?
No,
As a
see,
claim.
yes, as a claim, once the insolvency proceeding starts, see, you have to
Yes.
compile the claims for everyone, correct?
Yeah, yeah,
For
yeah.
admission of the personal guarantee, you just have to show that there is one guarantee which has been invoked and not paid.
Right,
So,
right,
for the purpose of admission into insolvency, you can show one personal guarantee, that personal guarantee, there being a default.
right,
So that you can show with respect to, say, for instance, if you have decided that I'll go to Ahmedabad, you show the personal guarantee given for that corporate debtor which is in Ahmedabad,
right, right,
and you show default with respect to that personal guarantee.
right, right. And when
Okay,
the claim will be asked for, then the banker of the other company will file the claim with that particular
correct,
RTA.
correct,
I got
correct.
it. I got it. Thank you.
All right. Yeah. So just I'm just going into the technicalities further, because what happens is generally jurisdiction. Not many people pay a lot of attention to jurisdiction, but as such, you will realize the issues in jurisdiction after, say, a lapse of 6 months. By that time, 6 months have lapsed, and then the banker comes back and says that I'm not happy. So that's why I'm just giving you these examples.
No, this is a very good example you have given.
Thank you. Thank you. So this is about NCLT jurisdictions. Always check what is the latest update on jurisdictions. Right now, they are not changing per se, but as you have seen that new benches had been formed. For instance, Kochi bench was formed, Indore bench was formed, Amravati bench was formed. So jurisdiction shifted from one NCLT to another. So whenever you are filing petition, check the latest status, that how many NCLTs are there in total, which NCLTs should I file my case in. Okay. All right. So this is regarding the first aspect of jurisdiction. Now let us see the subject matter jurisdiction. And I'm just giving you this example regarding subject matter, which we will go to subject matter jurisdiction of NCLAT also. But first, let us focus on the NCLT jurisdiction on a particular subject matter. Okay. So now, and I am not just dealing with subject matter of NCLT per se for insolvency code only, because as you know, NCLT has jurisdiction over multiple laws. One is they deal with company law. Second, they deal with IBC law. Now, in IBC, they also deal with personal guarantor law to certain extent. Then they also deal with certain provisions of RBI regarding deposits. So that way, NCLT's jurisdiction is quite wide when it comes to the subject matters that it deals with. Now, within that subject matter jurisdiction also, there are certain jurisdictions which are exclusively with the principal bench. So NCLT has numerous benches. For instance, in Mumbai NCLT, you have 5 benches. Then there are, out of all the 16 NCLTs that are there, there is one principal bench which sits in Delhi. So that is a principal bench. There are 2 benches in NCLT, as we have seen. I'll just show you once again. If you see in Delhi, there are 2 benches: NCLT Law Tribunal Principal Bench and NCLT Law Tribunal New Delhi Bench. So this is the principal bench where the main presiding judge of NCLT sits in this principal bench. Okay, so there are certain jurisdictions which are only there with that principal bench. No other benches of NCLT can take up that jurisdiction. As of now, with respect to IBC, none of the none of the matters in IBC have been exclusively given only to principal bench. Nothing says that this particular, say for instance, this section 9 or say this section 10 only will be heard by the principal bench, New Delhi. There is no such circular that I have seen. But with respect to Companies Act, there are three provisions which go only before NCLT principal bench. One is class action, one is applications of act with respect to foreign companies. So whatever applications have been to be filed with respect to foreign companies, they go there. And annual reports of government companies. So there are certain issues for which you can approach the tribunal. These three issues have been mentioned, which go to principal bench. Another important aspect from your end to deal with transfer applications, this issue goes before the principal bench. So what is a transfer application? For instance, in NCLT Mumbai, there is one company. Say for instance, we take example of which company. I'll just take example of one old company. Right now not many applications are there, but it was some these applications were there. So Gammon was a company in Mumbai. There were several applications under section 9 and 7 which were pending against that company. All right. So uh, in such a case, what can you do? So if you see that there are multiple cases which are going in multiple courts, and if you want to expedite the matter against that particular company, what you can do is you can file an application before the principal bench, and you can ask that, look, few section 7 matters are before court 1, few section 7 matters are before court 2, few section 7 matters are before court 3, some section 9 petitions are pending in court 5. So there are too many matters and too many benches, and all the benches are deciding whether to admit a petition against a particular corporate debtor. So you can make that request before the principal bench to club all these matters together. All right. So this kind of application can be heard only before the principal bench, and they have the sole authority to do that. Another example where you can ask,
who will be making an application to the NCLAT?
In that case, anybody who has filed a petition under section 7 or 9 can make that application.
Anyone can make.
Anyone
it's not
can make.
necessary that all should agree
No,
and
no,
then file.
not required. You're not required. And corporate debtor themselves can make that application, but they will never do so. So it is only one of the applicants and one of the eyes who can file it, saying that there are so many applications. If they are heard together, there will be a faster resolution.
But in any case, madam, what happens if any one of the application is admitted, other courts will direct to file a claim only.
Correct. But many a times what happens is the party tries to delay the matters. Corporate debtors at times try to delay the matters. So if and that has happened in a couple of matters. For instance, in Dolphin, we had seen that there were multiple cases everywhere. They were giving the same excuses before different courtrooms. So what ultimately happened was, when they were all clubbed together, the corporate debtor was not able to give the same excuses in every matter. So that way their bluff can be called out if the matters are all together. So there are some benefits of doing that, of clubbing the matters all together.
Also, if the advocates are not comfortable in a particular court, they may file an application before NCLT principal bench and go for a transfer application. That is also possible, I think.
No, I didn't get your question. Can you come again?
Also, if the applicants are not comfortable with a particular court or particular bench.
No. That such kind of application will be dismissed.
Dismissed. Fine.
Yes.
But some I have come across in cases where the judge himself had said, if you want, you can make an application to principal bench and have the application transferred to other bench.
See, here we are also dealing with advocacy, so it is not a good practice to cast aspersions
Agreed.
and to make such kind of applications, and that even the courts will not take it very lying hands down. That is not good practice.
Understood.
So I would not recommend it.
Understood.
Because every courtroom deals with every matter, and every matter is given the same importance. So as such, no courtroom we can say that your judge's preference, you cannot do what is that called, that forum shopping cannot be done, that this courtroom or that courtroom. Those forum shopping, if you do, that will be deprecated. And in fact, such kind of practices, principal bench has dismissed matters with cost in such cases.
Okay, noted.
Right. Now, another case where such transfer applications can be filed is where, for instance, you have multiple subsidiaries of the company. For instance, like I'm just giving you an example, not that it must have happened in that particular matter, but for instance, Videocon. There were 13 companies, different companies, group companies in that matter. Before all those got consolidated, there were 13 applications, and they can be filed in different courtrooms. So there you can seek that all these applications should come before one courtroom, so that a holistic resolution is possible. Okay, so
Can it be different states also, madam?
different states you can, as in there is no bar on the transfer of that, but I don't have any good case law to say that whether that can or cannot be done, whether the courtroom has actually considered such kind of practice in different from one jurisdiction to another.
Understood.
In these kind of cases, what you
Application can
referred
be done.
right now,
Yes.
in respect of IBC proceeding for different companies,
Right.
nowadays, as of now, there is no provision of merger of IBC of different companies one go. But practically speaking, these things are happening in some cases, I think.
Yes. Because for instance, in Videocon, they have consolidated all the applications, as in they have
Yeah,
given that
merge them
permission,
together.
that kind
Merge
of
them
order that
together.
you can check. And in another matter, one such other matter is Lavasa's matter, where they had asked that they had made that request that kindly consolidate these applications, so that we will be able to find a better resolution. So that is
But
like
ma'am,
I'm just
how things are possible if there is no provision in the IBC Act itself to
see.
merge all the applications?
Correct, but at least right now it is possible to file that transfer application saying that look, there is one company, there are three subsidiaries,
No,
all the
that is possible, but
that is
merging
possible.
all the cases in
Merging,
one.
merging this issue is there before the IBBI, and they are considering whether to file that, whether to create a provision for consolidation of this proceeding. In Videocon matter, to certain extent, that has been done despite there not being provision for the sake of simplicity. However, this issue is not there. There is no clarity on this issue, so let's not get into that, because that is a moot point. I agree with you
Okay,
that there is
okay.
no provision in the law, so you can't ask that kindly do it in a particular way. That may or may not be accepted, and in fact there are great chances that it may not be accepted. However, if you ask for transfer of all the matters before one courtroom, that power exists today in the law, and to that extent you may get that order. Are we clear? Should I
Yes,
move ahead?
yes, yes,
Okay.
yes.
Okay. So this is regarding transfer, the matters which are before the exclusive jurisdiction of the principal bench. All right. Then subject matter jurisdiction also, we need to see that who has the subject matter jurisdiction. Say for instance, in personal guarantors matter. Guarantors matter, subject matter jurisdiction depends on whether it is before NCLT or DRT. For instance, now in case of a corporate debtor, say for instance XYZ Limited, that company has been dissolved in NCLT. Okay. Or instance, take I'm just giving you I'm giving you names of companies, but I'm not giving you specific examples of those companies. Just take that as an example. Okay. So, for instance, Ruchi Soya. Today, Ruchi Soya's resolution plan has been approved, correct? So, Ruchi Soya is out of the CIRP process. It is outside the purview of NCLT, correct? So, if any of the banker wants to file a case against the personal guarantors, today, which court or which tribunal has the subject matter jurisdiction? The law provides that today DRT will have jurisdiction over that particular company, before that personal guarantor, because there is no proceeding going on in NCLT. So if resolution plan has been passed, it is approved, and it is outside the NCLT, then NCLT, no proceeding is pending in NCLT regarding CIRP process or liquidation process. Therefore, it is outside there is no proceeding going on, legal proceeding going on against the main corporate debtor. And therefore, DRT will have the subject matter jurisdiction with respect to that personal guarantor of Ruchi Soya. Okay. Another example is that if resolution plan has been approved, however, that resolution plan they are not able to implement, and the financial creditors file an application, because I am giving you the nitty gritties that what will happen in various cases. There's no standard answer to that, but you should know that when such kind of issues come before you, you should know that this can be a potential area where there can be a dispute, and therefore I have to be careful where I file. Okay, because as you have seen that the courts may take contrary decision. Tomorrow one decision can be there, but tomorrow there can be a different perspective. So I'm just giving you example where this subject matter jurisdiction will play a role. All right, so let us take example. For instance, there is a resolution plan which has been approved by NCLT. Okay, that resolution plan, the resolution applicant has not been able to fulfill. Therefore the company application has been filed, and this is the real life case where an application was filed for liquidation by the financial creditors, saying that this resolution applicant was supposed to pay say 50 crores within 3 months. They have not done it, and therefore there is a breach. We are filing for liquidation of this company. Resolution plan is not acceptable to us. And that dispute between resolution applicant and banker was pending before NCLT. Now the question before the bankers, the financial creditors, was that where to file the personal guarantor application. Okay, because one and they filed an application in NCLT. The personal guarantor said that look, resolution plan has been approved. There is no CIRP going on against the company, and therefore the personal guarantor's application should not be filed in NCLT. It is a jurisdiction of DRT. The banker said, no, 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 that is not the case. The resolution applicant has failed to fulfill its duty. So we have filed a liquidation application. So therefore, the subject matter jurisdiction is with NCLT because proceedings are pending regarding that corporate debtor in NCLT. The contrary, again, objection which was raised by the personal guarantor was no, no, no. Liquidation application has been filed, but neither CIRP process is gone because resolution plan has been approved and liquidation is not yet approved. So liquidation proceedings have not started. So there is neither CIRP proceedings nor liquidation proceedings. And therefore, this matter doesn't come before NCLT. So these kind of disputes, even regarding subject matter jurisdiction, can be faced by you, especially in case of personal guarantors matter. And that's why it is necessary to understand jurisdiction from a holistic perspective if you are planning to deal with matters with respect to NCLT. All
What
right.
was the outcome, man?
That's what I said. That outcome was that they ultimately admitted it. Then it went in appeal. So there are certain judgments that says that even if it is not in NCLT, still NCLT can take up the matter. So it is pending in Supreme Court. So I need to see what the Supreme Court has said. Otherwise, it is pending there. Yeah. So now we deal with the subject matter jurisdiction. I'm not giving you an answer with respect to that because there have been contrary decisions. And right now, NCLAT has said that even though NCLT proceedings are not pending, you can still file it, and certain tests have been laid down. So you will have to see those tests. You will have to see this latest subject matter, because if I tell you an answer today, that answer may not be valid at the time when you are filing, because you are yourself aware and you have seen NCLT, NCLAT judgments and Supreme Court judgments, especially in case of limitation. Today something was considered to be valid, tomorrow something was not considered to be valid. So therefore these answers, whatever are true today, may not be true tomorrow. Okay, so that you will have to see when you are actually filing the petition, that what is today's stand with respect to a particular subject matter. Okay.
Yes, yes.
Okay. Now, second, we come to the pecuniary jurisdiction. I think there has been a lot of discussion regarding pecuniary jurisdiction. But this also, you have to be careful when you are filing any application or petition in NCLT. Now, what is the pecuniary jurisdiction under Section 4 with respect to CIRP matters? It is 1 crore. However, even in that, there have been a lot of case laws regarding this. So therefore, whenever you are filing that Section 7 petition, you still have to understand that am I really within the pecuniary jurisdiction or not? For that, let me give you certain examples of the uh, multiple types of issues that have arisen with respect to this particular threshold limit. So first question that had come before the court was that there were petitions for say 40 lakh. which was filed in NCLT, but this petition under section 9 was filed for 40 lakh in the year 2019. So will that petition, which was filed in 2019, become barred under section 4 because of the change in threshold limit? That was the first question that was raised before the court. Second question was that I have sent demand notice. I have sent demand notice in 2019. I have filed the petition in March 2020, March 20, after March 2020. So while my demand notice is before the increase in the pecuniary jurisdiction, my petition has been filed after the increase in the pecuniary jurisdiction. So whether I am barred under the threshold limit if my amount is 44 lakh. Third question. Third question is that my principal amount is 40 lakh, but the interest on that is 65 lakh. So technically my entire amount is for 1 crore. So will I be allowed to file or will I not be allowed to file? Am I above the threshold limit or am I not above the threshold limit? Fourth point. My entire claim is of 1 crore. However, there are certain invoices out of that which are barred by limitation or that are barred under section 10A because 10A says that any default during that period between March 2020 to March 2021, that period of default, you can never ever file an IBC petition with respect to that default. So though my amount is above 1 crore, my 70 lakh invoices are within limitation. My some 30 odd lakh invoices are barred under section 10A. So technically I am above 1 crore, my 70 lakh invoices are within this, my 30 lakh invoices are under section 10A. So will I be allowed to file this petition? So that way there were multiple issues that arose out of this small issue of threshold limit. All right. And that slowly over time, the law has been emerging. So let me just give you one or two examples of how the court has dealt with this aspect. So first, with respect to if I have filed a petition in 2019 and my amount is below 1 crore, it does not matter because this petition has been filed prior to the increase in the threshold limit. That petition will not be heard by the change in section 4, the change in the pecuniary limit. So that was the first question which was answered by the court. The second question, with respect to my demand notice being before, but my petition being afterwards, has been answered in certain case laws like jumbo paper, where they have said nothing doing. You have to see whether section 9 petition, the date it was filed, whether it is above 1 crore or not. That was the second question which was answered. Third, regarding interest, there were two contrary judgments of NCLAT. One which said that, look, this petition, the invoice itself records the interest rates. So there is a contract in place that provides that I have an amount which is pending, and if that amount is not paid within a certain time limit, then this interest is payable. So both the principal as well as the interest are contractually payable to me, and therefore there is a default. So that was one case where they said, yes, it is above 1 crore, we are accepting it. But there have been contrary decisions also of NCLAT, where they have said that, look, interest cannot be considered for the overall pecuniary limit of 1 crore, and therefore you cannot file it. So in case where such kind of issue are there, you can take your chances and file the petition if there is some issue. Regarding 10A matter, there are many cases where based on 10A, certain proceedings have been dismissed. However, on face of it, your petition will not be dismissed. You will have to file the corporate debtor will have to file a maintainability application, show that there is a 10A bar, and only then the petition may or may not get admitted. That is how you deal with the matter. And whether you say that there is a continuing cause of action, and therefore those invoices are a part of the overall invoices which have been raised, so that is not the date of default within 10A and all that, and that way you can try to avoid a petition like that getting dismissed. Okay.
The recent case is in the case of Srey also, they have taken this plea basically.
10A.
Yes.
Yes.
The default was happened in between that period. So even after issuing the interest and all, they have now claimed that the default was made between that period, so it is not maintainable or something like that.
Correct. So these days 10A is a very regular objection which is taken in multiple matters, saying that this particular default has arisen under the suspension period, and therefore this section 7 or section 9 petition is not valid. Okay, so that pecuniary jurisdiction has to be taken care of. Now in certain section 10 petitions also we have faced that problem where the company's overall debt is not above 1 crore, and that happens in case of small companies. Certain people want to close down their companies, but their debt is not above 1 crore, so they are not able to file a petition at all these days. Neither they are that I'm just giving you an example. There is there is a company, they have employee debts of say 15-16 lakh rupees. They have few operational creditors whom they have to pay. The total amount is not coming above 1 crore, so you can't file it under section 10. You have no financial creditor whom you can take a consent and file a pre-pack insolvency program, so there is the threshold limit of 10 lakh also you are not able to meet because you don't have a loan in your account. So what to do? Any answers? That if that person wants to close
Ma'am, in this case also, sometimes what happens, say I have a financial creditor in my
right.
books, and the loan I have taken is 50 lakhs only. And after adding the interest thereon, it goes beyond 1 crore rupees or something like that. As you said in the case of the supply of goods also. And there are some creditors also lying in my books. And after considering the interest portion on that, if it goes beyond 1 crore, will that concept of original amount outstanding will apply here?
See, the courts have taken a stand in certain cases, that and that really depends on a case to case basis, because courts have looked at the principal amount and said that look, your principal amount is below the threshold limit, I am dismissing your petitions. But there have been one or two cases where despite it being below the threshold limit, petitions are being considered. Okay, so this really depends on the contract, the manner in which the contract is worded, the invoice, what is mentioned in the terms of conditions of the invoice. So there is no standard answer for this question.
And what about the financial creditors? That there it is matter is clear, I think.
I think that matter is clear because see, see, I am telling you there are two types of financial creditors. One is that bankers, and bankers loan I'll hardly see that it is less than 1 crore, as in only in case of cooperative societies and all the matter may be below cooperative banks. The amount may be below 1 crore because 70 lakh and all is the amount for them. But rest, most of the bankers are above 1 crore. And in any case, a loan agreement will contain the terms regarding the interest and penal interest and all that. So definitely, if that is above 1 crore, the court should consider. Now, second part is regarding loans which are taken from people like directors. Sometimes even directors or promoters file a case saying that I have given a loan and my loan is not repaid, especially when there are some internal fights going on between the companies. So in that case, this 1 crore limit, this 1 crore limit may be a question because interest and all is not there. Generally, there is no agreement between the parties. So that's why, as I told you, that it's a very case-to-case basis that you have to see that who is the financial creditor. Is it a bank? Is it, what does the loan agreement say? Is it a private party? Is there a amount which is mentioned between the private party? Is there some kind of contract? Is it shown in the balance sheet? What kind of amount is admitted in the balance sheet? All those things will come into play. All right.
Okay.
If we have no agreement, can we file a petition? If there is no agreement.
Yes, there have been a couple of conflicting decisions even on that. My sense is that if you look at the law, it talks about if you just look at the AAA rules, they say that you have to give details about what is the financial contract, what are the details regarding interest, repayment, and all. So, even on the basis of an oral financial contract, if you have documents to show that yes, a financial contract exists, you can file a petition, but you have to define the terms which are mentioned in the rules. You look at the adjudicating authority rules, there is a financial contract and they have shown what kind of details are required. If you are able to provide that those details, especially say for instance an email, or you can show that since so many years TDS has been paid, interest has been paid, later on they stop paying interest. So based on this circumstantial evidence, if you are able to give, and even if it is an oral financial contract, you may be able to succeed.
And if it is mentioned in the balance sheet,
If it is
then
mentioned in the balance sheet, your case is stronger. And now there are judgments that says even interest is not required for the purpose of a financial contract. So even if the interest component is not mentioned in the balance sheet, but the principal amount is mentioned as loans and borrowings, yes, you stand a chance.
okay. Thank you.
Yeah, you're welcome. So regarding 54A, you have a pecuniary jurisdiction of 10 lakh. Even here, it doesn't say that 10 lakh have to be from the financial creditor. It says a overall debt and default of more than 10 lakh. So that if you are able to show, an MSME can approach the court under 54A if it fulfills other requirements of the law. For personal guarantor, the limits are so less that there is no point in talking about it. For a fresh start insolvency, which is like, which I think no personal guarantor will be able to take advantage of, that is 30 less than 35 lakhs, 35,000, and above 35,000, it is the regular insolvency process. So there are two particular applications that can be filed. Fresh start in the sense that complete debt gets it's only for people who are like in a very low income bracket, who are not able to pay a debt of 35,000 odd rupees. So
Ma'am,
I think
excuse
most of
me,
our,
ma'am.
yes.
Yeah, one small doubt, madam. I typed in the chat box also. Now I am an RP only, madam. I am not an advocate.
Mhm.
So with that status, could I file a section 7 or 95 application for the creditors? And can I act as an proposed IRP also?
You can't do both. You can either file the section 7. You must be a chartered accountant, company secretary.
Yeah. Company secretary and RP, madam.
So if you are a PCS or a PCA, you will be able to file the application. But as an RP, you cannot file a section 7 and put your own form too, because that there will be a conflict, and the other side will take an objection to that, and the court will consider it.
Okay.
Okay. Yeah, because an RP has to be an independent party, so you filing it there will be questions which will be raised. Okay, so somebody else has to file the section 7, section 9 petition. You cannot file it yourself if you are planning to file your form 2. All right, shall we go ahead? All right.
Yes, ma'am.
Yes.
So I'm sorry, there are some grammatical errors. I've done this in a hurry. So just now we have understood the basics. What to file for, where to file, we have understood regarding jurisdiction. Now we will see under which section to file. Okay. So in that, I'm just going to give you few examples. So let us take certain examples with respect to where to file, under which section to file. I'm just going to give you certain examples. Just wait. Yes. Now, the problem is an ex parte order has been, I'm just giving you example, just see if you are able to find that answer. An ex parte order has been passed. Which section will you file an application under? For instance, a section 7 petition has been passed, ex parte order has been passed for admission. The corporate debtor comes to you and says, sir, what can I do? Will you go to NCLAT or will you go to NCLT?
In CLAT
Anybody?
only. In CLAT only.
No, you have two answers, two solutions. And here you need to look at NCLT. It's okay. You can go to NCL, you can go to NCLAT. That is not a problem. But there is a provision in NCLT rules that says that you can also go for ex parte orders against, just 1 second. NCLT rules. Yeah.
What is the rule number, ma'am?
Just 1 second. 49.
49.
See, I'm just giving you this example. You may or may not use it, because ultimately a Section 7 admission is something which is going to create havoc in the corporate data. So most probably they will go to NCLAT. But if it's some other matter, for instance, some small issue where an ex parte order has been passed, then in that case where you can take a risk, you can file a application under Section 49. What does Section 49 say of NCLT rules? When on the date fixed for hearing of the petition or application on any other day to which such hearing may be adjourned, application appears and the respondent does not appear, when the petition or application is called for hearing, tribunal may adjourn the hearing or hear and decide the matter ex parte. So where a petition or an application has been ex parte against a respondent or respondents, such respondent or respondents may apply to the tribunal for an order to set it aside if such respondent or respondent satisfy the court, one, that notice has not been served, or he or she has been prevented from sufficient cause from appearing for hearing, and the tribunal may by an order set aside this ex parte order. For instance, I'll give you example where you can use it. Matter is going on, and today all the hearings are going online. Somewhere it can happen that you are not able to log in, or you're finding some problem. You have written to the NCLT, you have written to the court officers, I am not able to log in, please allow me to log in. And because that matter is going on and you have not been able to appear, or your lawyer has not been able to appear, and because of some technical issues, in that case, if an order is passed, you can very well next day or immediately file an application before NCLT, say that look, this ex parte hearing has taken place, this ex parte order has taken place, and there were certain technical difficulties which you will have to show certain proof that you can't just bluff. You will have to show certain proof that I have taken efforts to log in, I have written to the NCLT, I have sent an email, but I still wasn't able to log in. So or you can write to the other side that I am not able to log in, please wait. And if despite that still an ex parte order has been passed, you can very well file an application, produce this proof before the court, and the court doesn't have a power to review, but they have that right to set aside an ex parte order. So therefore, whenever you are filing an application, you need to know that what are the powers of NCLT. Okay, so this is just one example.
But in IBC case, I think better step will be to NCLAT, because we can take this additional ground over there.
Yes. Section 7, Section 9, I would not anytime recommend going for a Rule 49.
Right.
But in other case, say for instance, an application is filed, some small thing is there, for all the way the expenses are too high to go to NCLAT. In those cases, you may consider filing this application under Rule 49.
Very true. Very true.
So that way, sometimes that cost benefit and the importance of that particular order has to be seen, and accordingly you can take that view. But you need to know, I'm just giving you an example, that sometimes there are certain provisions in the law. If you know them, you will be able to use them in certain circumstances, right? So
yes,
this was regarding where to file and where to go. Now, another issue regarding this is, for instance, an arbitration award. There is before the CIRP starts, an arbitration award under CIR, arbitration award has been passed against you, okay? Against your corporate debtor. Where will you go? Any answers? There is an arbitration award which has been passed before the CIRP start against the corporate debtor. As a RP, you want to challenge it. Where will you go? Will you go to NCLT or will you go elsewhere? And why?
You say during CIRP award has been awarded?
No. Pre-CIRP.
Okay. Thereafter, CIRP has been initiated.
Yes.
So moratorium will not apply over there?
No, arbitration award, nobody can execute that award. But ultimately, as a corporate debtor, you will have to challenge that arbitration award, correct?
Okay.
Because it is against your company, against the corporate debtor, and you have to protect the interest of the corporate debtor. You want to challenge this award.
So the next higher authority, I think, is High Court in that case, isn't it?
Yes. So therefore, as an RP, you have to decide which court you have to go to. You are absolutely right. Which court you have to go to. First, some people may say that, look, there is a moratorium beginning, so why do we take the effort of filing an arbitration award? There is a limitation period is extended. But please note that under section 14, there is no bar against a corporate debtor from taking action or filing petitions against any party. What does section 14 bar? Section 14 bars that no legal proceeding can be taken against a corporate debtor. No proceedings can be continued against the corporate debtor. But there is no bar against the corporate debtor initiating petitions, because even in arbitration, and the reason why I'm taking an example of an arbitration and conciliation act is because the way in NCLT, there is a time limit. For instance, if an order of NCLT has to be challenged, you can challenge it within 30 days. In NCLAT, plus additional time of 15 days is given to you to challenge that by taking condonation of delay. But beyond that, you will not be able to challenge an NCLT order after 45 days. Correct? So similarly, Arbitration and Conciliation Act has provisions which have stringent timelines. So as an RP, you may say, oh, there is no problem. This award can never be executed. However, if tomorrow, after the CIRP is over and you want to challenge, I'm just giving you an example that if you want to challenge, say for instance, mining leases or something of that sort, if you want to challenge that, and if there is a time limit given within which you have to challenge it, tomorrow the other person will not be able to challenge this award because limitation will apply. You cannot say that the limitation is excluded because there was no bar on limitation. There was no bar against you filing the application for the corporate debtor.
Out of the way question, ma'am.
Yes.
Say this, the arbitration awards has been awarded pre-CIRP.
Correct.
And the RP has not taken any step for filing appeal before the High Court, and the resolution process is going on, and the resolution plan are being received. So do you think that in case of resolution plan, the provision for award arbitration award has to be considered in the resolution plan?
In that case, it depends on whether the applicant has filed a claim or not. Because if you have an award in your favor, then technically you should file a claim saying that this is the amount that I
No,
am
say it is otherwise. The other party has got an award against the corporate debtor. They
before
are
CIRP.
supposed to take amount from the corporate debtor. In that case, I'm asking.
Can you come again? Who
I'm
has,
saying-
I'm just giving you an example. Say
Yeah.
ONGC has got, there is a petition, there is an arbitration going on between ONGC and your corporate debtor, okay, an infra company, okay. Now, an arbitration award has been passed, this infra company is the corporate debtor. So is the award passed in favor of the infra company or in favor of ONGC?
ONGC. CD has to pay some amount to the ONGC.
So ONGC has got an award in its favor.
Right.
All right. Now, what is the question?
Question is, say in that case, what happens? You are, as per your view, RP has to file an appeal if he wants to before the High Court. He can file during CIRP, isn't it?
Yes.
Yeah.
There is no bar.
Say he has not considered it to file the appeal, and the process of CIRP is going on, and the resolution plan has already come. So is RP is bound to give provision for the amount of award in the resolution plan or not?
That depends on whether ONGC has filed its claim or not, and whether that has been considered as a part. Because see, ultimately, as a resolution professional, you have to consider the list of creditors. So if in the list of creditors, ONGC is shown as a claimant for that particular arbitration award, then you have to consider it. In the VDR, you will have to display it, that these are the awards, these are everything, and the resolution applicant can say that this arbitration award, nothing is payable under that. Or if at all it is an operational creditor and they are paying only 1% of the total amount payable to operational creditors, they can say that for the arbitration award also we will pay 1% because it is also an operational debt.
No, that is a different issue, ma'am. I'm not going in that depth. My
Correct.
question is very simple. If the arbitration award has been awarded and no appeal has been filed by the RP, will the resolution plan will consider that award or not? Simple question.
You will
Whether
have
it
to
is a
discuss
operational creditor or I'm not
whether
going
the
into that.
resolution professional, whether the resolution plan considered is or not a different thing. You will have to show it as a part of the VDR. You will have to disclose it.
Because in many of the cases, even though a claim has not been filed, and if the balance is reflecting that debt in the balance sheet of the debtor, corporate debtor, there are certain views by the judicial, even I think in the case of Supreme Apex Court also, that the RP has to consider that amount, even though the claim has not been filed.
See, now there are two different set of laws. Say, for instance, Ghanshyam Mishra says that if you don't file the claim and if you are not vigilant enough, then those claims cannot be considered. Later on, you cannot file it. So whether claim has been filed or not is important, but you can disclose it and your responsibility ends there. Okay.
Okay, thank you.
Yeah, yes. So this is regarding arbitration award. That doesn't go to NCLT. It will go to the appropriate forum. That is the High Court in a Section 34 appeal under the Arbitration and Conciliation Act. These matters do not come before NCLT. Why? Because that sometimes happen that which court to file. Because now the law is very clear regarding which matters can come in NCLT. I'll give you one more example. This is the case of TCS versus SK Wheels and versus Gujarat Urja. Okay, so there were two judgments with respect to the use of section 60, subsection 5C. Section 60. Okay. So just to give you a flavor that SK Wheels was under the CIRP process. Now, Tata Consultancy Services had a contract with SK Wheels. Now, Tata Consultancy Services wanted to terminate its contract with SK Wheels because they were not performing. There were various problems in the contract. They were not providing services as was required by Tata Consultancy Services. So during the CIRP process, they terminated the contract. It was regarding some services to be given. So TCS terminated the service. Now the resolution professional filed an application in NCLT under section 60 subsection 5 subsection C saying that any issues which arise during the CIRP process including this termination being invalid should be considered by NCLT. So without going into the facts of that case, the issue was that there is a contract which has been terminated during CIRP process. Now, whether that termination and whether it is a valid termination, this issue should come up before NCLT or not. Getting me? So a contract is terminated. TCS has terminated its contract with SK Wheels, saying that you are not providing services as per my liking. So I am terminating the contract. Now, a application has been filed under section 65C saying that, look, TCS, you have wrongly terminated the contract. You should continue this contract with me. And this termination is invalid. So this issue had gone up till the Apex Court, and Apex Court has created a distinction with respect to when can you use section 60 subsection 5 subsection C, because as you know this is the most widely used provision. Whatever happens apart from the regular section, every application goes under this default section of 60 subsection 5. So this is an important judgment that all of you should read, where the scope of section 60 subsection 5C has been circumscribed. So what the court has said in this case is...
What is the case reference, ma'am?
A case reference in the sense? This Tata Consultancy Services versus SK Wheels Supreme Court judgment. You can go to
Tata
IBBI.
Consultancy Services.
Yes, yes.
Okay.
Tata Consultancy. Just go to IBBI's website. In orders of Supreme Court, press Tata Consultancy Services. You will find this particular case law. Okay. So now the question before the court was that what is the extent of 60 subsection 5C? Can the NCLT deal with cases of termination of contract? Okay, and court said that this termination was not because the company went into insolvency. TCS was not happy with the services provided by SK Wheels. TCS was writing to SK Wheels that your services are defective, your services are deficient, not up to the mark, and therefore we are cancelling your contract. So maybe the procedure, if it is wrong, these issues cannot be taken up before this particular authority, that is NCLT. It will This issues cannot, such kind of termination of contract and validity of termination of contract cannot be decided by the court unless it is something to do with insolvency. It has a direct relation to insolvency. And in that case, they distinguished this matter from Gujarat Urja's Supreme Court case. Because Gujarat Urja's Supreme Court case was that there was a contract between two parties, that the Gujarat Urja and the corporate debtor. What happened was, the moment corporate insolvency resolution process started, the company said that, look at my contract. Contract says insolvency proceeding, if they start, the contract is considered terminated. So the moment CIRP process started, they showed that clause that says, look, the moment insolvency process starts, this is a default by virtue of which you ceased this contract ceases to exist, and therefore the contract is terminated. So court said that in TCS case, in the Tata Consultancy Services case, their contract was terminated because they were not getting proper services as per the contract. Whereas Gujarat Urja's matter, the in that matter, the services were terminated just because insolvency started. So to continue the company as a going concern, they have to, that contract, whether the continuation is necessary or not, they had to deal with it under section 60 subsection 5. So in that case, it should go under section 60 subsection 5 C, and not under before any other authority. So therefore, which applications will go to NCLT and which applications will go to a different forum will depend on what type of matter it is. For instance, if you want to challenge and in that same context, I'm saying that if you want to challenge an award, you will have to go before the appropriate forum. For instance, in another case, say for instance, there is some reservation done, or there is some mining lease which has been cancelled. So in that case, you will have to look at the law as it stands. And again, I say the same thing, that don't take me at my words today, because as we have known that the law is evolving. So what the stand taken by the court with respect to a particular thing has to be seen at that point of time, and a decision has to be taken by the resolution professional or the liquidator. So I cannot give you a standard list that go to NCLT, don't go to NCLT. You will have to see it considering the law as it stands on the date where you want to go ahead and file the application. Okay. So this is just one of the example where whether to go with NCLT or whether to go before another forum, this kind of issues can be dealt with. Okay. Now we come back to the next. Are we clear on this?
Yes, yes.
Yes. Okay. Now there are certain cases where you don't have a section under which you can go before NCLT, but that is required. You are required to go. So you have a standard section, rule number 11, under the NCLT rules,
Yes.
where you can file an application if there is no provision per se. For instance, if you know, before NCLT provisions came into force, before 12A came into force, the question was that if you want to settle prior to the COC being constituted, there was no provision in the law. So there, the court had
Can
said,
I interrupt here?
yes,
Can you
yes.
just distinguish the power of NCLT under section 60, subsection 5, clause C, and rule 11, just for the sake of understanding? What is the, I mean,
Okay. Let me
ultimately,
just,
yeah. In any case, just we discussed the earlier case, na, ki if something is related with IBC and there is no specific section, then under section 60, subsection 5C, the court can take a view regarding that.
correct.
And the
So let
same
me,
situation is arising if for the sake of justice, rule 11 can be applied. So can I just know the fine difference between the two?
yes. Yes. Should I give you? I'll give you the example of 12A, because 12A was the classic case where this issue of Rule 11 versus company versus NCLT IBC law had come up. Okay. So I will give you that example. Now let us look at subsection 65. What does section 60 subsection 5 says? It says any application of proceeding by or against the corporate debtor or against a corporate person. That application can be filed here. Any claim made by or against the corporate debtor or corporate persons, including claim by or against its subsidiary situated in India. Any question of priorities or questions of law or fact arising out of or in relation to insolvency resolution or liquidation proceeding of corporate debtor or corporate persons. ठीक है? All right. So this is what is section 60 subsection 5. Now I will give you two examples. Before 12A came into force, 12A, before it was amended and section regulation 30A was in regulation 30A was inserted, it said that you take 90% consent of COC and only then you can file an application under 12A. Correct?
Yes.
Right. So there was a specific section that dealt with a provision regarding withdrawal of insolvency process. Now,
Yes.
now, what if the situation was that COC is not constituted, parties have settled? Say, for instance, there is a vendor who was supposed to be paid 1 crore rupees. Now the promoter is saying, I'll pay you that 1 crore rupees, please settle. 12A is not amended. Okay, so 12A says 90% consent of COC. So do you wait for the COC to be constituted? Or what do you do? Do you have any other provision
Actually,
in
in
the
this case, there are three propositions, ma'am. One
Yes.
is the case is filed and has not been accepted. In that case, Rule 8 will apply in
No,
the
we are
case
not
of.
dealing with that because that
No,
was very
no,
clear.
I'm just telling the
Yes.
proposition.
Yes.
The
Yes.
first proposition is before accepting, and that is very much clear under Rule 8. And the second proposition is after filing. After filing, there are two propositions. One before constitution of COC and after constitution of COC, if I'm clear.
Correct. Absolutely. So
So
let us take an example.
after formation, the law is very clear under section 12A.
Law was not clear. That is what I'm saying. That at
No,
that
after
point,
amendment, I'm saying.
after amendment, it is very clear. So when
Yes,
there is
yes.
clarity in the rules, you don't need Rule 11.
Yes, yes.
When there is clarity in any regulation, you
You are
don't need
talking
Rule
about
11.
before amendment.
Yes.
Okay.
Because we
Okay.
are seeing what the question which you have raised is that in what situation do you use Rule 11? Rule 11
Yes.
is the inherent power of court, which otherwise, if there is a direct provision, you don't need Rule 11.
Right.
Okay, it is only when there is a situation where you want to approach the court, there is no provision in IBC, there is no provision in the IBC regulations, what to do? That is the time where you can take advantage of Rule 11 of NCLT rules. Okay, so I am
Right.
giving you two examples which come to my mind. The first example is where in Swiss Ribbons, court had recognized the importance of Rule 11 in terms of withdrawal of CIRP proceedings before COC is constituted. So court said that look, 12A says that 12A before amendment. Again, I am talking about 12A. I'll first explain what is 12A and what is withdrawal. Section 7 petition filed against a corporate guarantor for say 1 crore rupees. That petition is not yet admitted. And the financial creditor and corporate debtor both decide ki theek hai, we will close this matter, we will get you pay me in 5 installments, I am okay. Before admission, no problem, court will say all right, give me the consent terms, I am closing this matter, no admission, matter is dismissed for default because in terms of the consent terms. Okay.
Yes.
No
Yes.
difficulty there. Now, the problem was arising before the insertion of 12A. At that time, what had happened was Lokhandwala was one of the first cases where admission took place. Say, for instance, financial creditors, a 1 crore claim, they saw debt and default, they admitted the petition. Now, Lokhandwala is saying that this was before 12A. I'm talking about before 12A. So before
Right.
12A was inserted, the question came that look, after the admission of the petition, I am ready to settle with you. So please settle. NCLT said, I don't have the power to do it because there is no law, no 12A. 12A was inserted later on after that Lokhandwala's matter in Supreme Court. So they said, we don't have the power to do it. Where, show me where is the law of withdrawal of the case after NCLT, after the case is admitted. There was no such provision in the rules, AAA rules, as you rightly mentioned. Rule 8 was there that before admission, you can settle the matter, no difficulty, you can withdraw the application. But after that, before 12A was introduced for withdrawal after admission, they said there is no such provision, so we can't do it. The matter went up to the Supreme Court. Supreme Court said, I am exercising my extraordinary power under Rule 142 and I am letting you do it. So everybody started going before Supreme Court, filing an application to Supreme Court that we have settled, it is admitted, there is no provision in law, kindly consider. In that background, Section 12A was introduced because the court said that there should be a provision to settle the matters. So in light of that, Section 12A was introduced in the IBC regulation, where they say that if you want to withdraw a petition, in that case, what you should do is you should take 90% creditors, 90% consent from COC, and if they admit, you withdraw it. Now, even in that, there was a precarious situation. Why? Because 12A said withdrawal. Does NCLT have the power to withdraw? Yes. After admission, NCLT has the power to withdraw. What is the precondition? The precondition was 90% consent of COC. Now the question was, what if there is no COC? The power is there to withdraw with NCLT, but that precondition is not satisfied because it does not exist. For the first 1 month, when there is no COC, that condition, it is impossible to fulfill that condition, right? So in that scenario, the Swiss ribbons, in the Swiss ribbons, this issue, when it had come up, court said that, look, Rule 11 is an inherent power of the court. Court cannot allow anything wrong to be done. So when there is a situation, when the law provides withdrawal is permissible, but COC is not constituted, you can very well withdraw and allow by using your inherent powers under Rule 11, right?
Yes, yes.
Got it?
But
After
it was happened only after the observation of the apex court, not before that. I mean, they have not utilized that power before that.
there was a little hesitation, I agree, with respect to
Yeah,
use of this power. In certain NCLTs, they had used it. In fact, I can
okay.
give you an example in NCLT, in Mumbai NCLT. In fact, that was exercised. That came up for criticism before the Swiss Ribbon judgment, but ultimately Swiss Ribbon recognized that power. Okay? So
Yeah,
it is not, but many courts were hesitant to use Rule 11 in that particular case until
right.
clarification had come. So of course, uh, Rule 11, when you're trying to exercise a power which is not there in the act, of course the court will hesitate unless you show that this is a good ground for exercising the inherent powers. They
Very
are not
true. Very
exercised lightly. They are lightly. Okay. So that is one example. Now another example I will give, and that is a very peculiar issue that has come up in Bombay NCLT. In Bombay NCLT, as you know, that several courts, there are 5 benches in NCLT. During there have been many judges who have retired over time. So there was a peculiar situation that had come up, and in that light, I'll just show you 152 first, and then we will. No, this is IBC, the NCLT rules. Yes. So let me give you one more example where the request was made to the court to use Rule 11, and I'll explain why that rule was required. Now, all of you know that when a matter is decided, say for instance, a Section 9 or a Section 7 petition is decided, court generally reserves the matter for orders, correct? Right?
Yes,
They
ma'am.
hear both the parties and they reserve it for orders, saying that, okay, I will decide whether to admit the petition or dismiss the petition, correct? So,
Right.
many a times it happens that, say, for instance, a matter has been heard, but unfortunately, one of the members retires before the order is passed. In that event, what does the law say under Rule 52 of NCLT rules? Just I am reading that for your benefit. If the order cannot be signed by the reason of death, retirement, resignation, or for any other reason by any one of the members of the bench who has heard the case, it shall be deemed to have been released from the part heard and listed afresh for hearing. Correct? No difficulty there. So an order has been heard, a matter has been heard, both the parties have been heard, matter has been reserved for orders. Now that order does not get passed, and in the meantime, one of the judges or both the judges retire. Okay? So now you will file an application under 152(4). You will say, look, this order was reserved for order, but none of the parties, the order has not yet come. Both the members have retired or one of the members has retired. So this matter has to be heard afresh. No difficulty there. The court in the regular course, can somebody just close there? I think there's somebody.
Anup Kumar, your thing is, please switch off. Please switch off your thing.
Okay. So no difficulty there. There is a clear-cut provision under Rule 152 that says that if the order is not passed by that time, then this order will be released from the part heard. In that case, no need to use Rule 11 because it is a straightforward decision. Correct? Correct? Are we
Yes,
clear?
ma'am. Yes, ma'am.
Order matter, Section 7 petition heard, Section 7 petition reserved for orders. Section 7 order not passed. Judges retire. So you go to the bench under 152(4). You say that, look, the order has not been passed. Kindly release this from hearing and list it afresh for hearing. List afresh for hearing. Court will allow that. Now, there were some situation in NCLT Mumbai where what happened? Section 7 matter was heard. Both the parties were heard. Thereafter, matter was reserved for orders. All right. Thereafter, matter was posted before the bench for pronouncement of orders. You have seen how matters get listed for pronouncement, correct?
Yes, yes.
You have seen
Yes.
that there's a column which says pronouncement of orders. It's not here.
Yes, yes. First column.
Pronouncement of orders, right? Like
Yeah.
this, the matter was listed for pronouncement of orders. Okay. But what happened was that the order was pronounced saying that, all right, your Section 7 petition is dismissed. Okay. But the order which came, the final order never came up. So, in the open court, they made a statement that, look, this Section 7 petition is dismissed. All right. In the order which came up, it says Mr. A appears for party 1, Mr. B appears for the respondent, or separate order is pronounced by separate order sheet and petition is dismissed. Okay. But this separate order sheet never came up. So now what to do is the question before the court. Is the order not passed? It says that order is pronounced by its separate order sheet, but that order is not available before the court. The order could not be found. The order was never uploaded, final order. So what is to be done in that situation? So is there a law which is there some provision in the law which is there? Is 152 dealing with such kind of situation? Look at Rule 152. 152 talks that if a member of the bench who has heard the case are not readily available or has ceased to be member, president may authorize other members to pronounce the order on their behalf on satisfied it has been duly prepared and by all the members. So here the members pronounce the order in the open court saying that yes, we have dismissed the Section 7 petition. But the order which came, the order said that say Prachi present for the respondents, Mr. A present for the petitioner, petition is dismissed. Okay. And order by a separate order sheet, order is pronounced and the petition is dismissed. So there was a reference to another order sheet in that order. If you have seen any orders of NCLT, you will see that one order sheet records who have appeared on the date of pronouncement, and there is a separate order sheet by which the order is recorded. So that second order by which the order was recorded never came up. The question was that it is not the case that this order is not signed or it is signed. We don't know what has happened. We don't know whether has the order been pronounced. Yes, order is pronounced. But is it the case that it is part heard? No, matter is not part heard. Is it the case that order is not pronounced? No, order was pronounced, but no order is available. So this was a peculiar situation before the court. And in such cases, I'm just giving you an example. In such cases, it is possible for the court to use Rule 11, because you cannot, nothing in this rule shall be deemed to be limited or otherwise affect the inherent power of court to make such order as may be necessary for meeting ends of the justice or to prevent abuse of the process of the court. So in this case, court said that, look, if the final order is not there and the order sheet is incomplete, it says order to be passed by a separate order sheet. So any reasonable person will wait for the order sheet to be uploaded. So by that time, those 45 days can be passed. So for meeting the ends of the justice, if an incomplete order is there, it is the court's responsibility to reopen it. Otherwise, that will be necessary for meeting the ends of the justice. So in such a kind of scenario, courts have exercised their power under Rule 11, read with Section 152(4) for reopening this matters. So just this is an example of how, which provisions and where can you use this power. Okay.
Thank you, ma'am. Thank you.
Okay. Okay. So what happens is when you look at real life scenarios, it gives clarity as to how provisions are used. Right. So now let us go to the next part. Now we have seen understanding the basics. We have seen jurisdiction issues. In what kind of applications that can happen, applications also to be filed. I'm going to show you how it is to be drafted. Where to file is the question which we have answered in jurisdiction. Under which section to file, we have seen that there are multiple sections which you should know apart from the sections in IBC, because like Rule 11, which will be of use to you in certain peculiar situation. Now, what to argue and timelines, that we will see. So let me go to what to file, because this is also an important, like how do you draft a petition, because we have seen now the sections under which it is to be filed, we have seen the jurisdiction where we have to file, but what is the care that we should take while drafting a petition. So for that, what I have done is I am going to take you through a petition under section 59, because all of you must be dealing with section 59. It's a standard. The voluntary winding up is the most regularly used section. Many people in the regular course do the entire matter themselves. They only file the application before NCLT. They only ultimately argue the matter before NCLT. So I thought that rather than going into drafting per se and drafting of various applications, let us look at a real life example. I think there's some disturbance here. Can you please switch off your mic? I think somebody's mic is on.
Yeah, looks like he has muted it. Looks like he.
Vimalji, can you please mute your mic? Yes. So what I feel is that rather than going into drafting and looking at do's and don'ts of drafting, let's go into the real life example of, say, for instance, arguing and filing a Section 59 petition. All of you must have been familiar with Section 59 of IBC. I'll just take you through that section once to deal with the nitty-gritties of any matter. Just 1 second. First, let us go to the IBC Act. How many of you have dealt with the Section 59 matter, voluntary liquidation?
Yes, ma'am.
Many of
Yeah,
them have dealt with. That's a regular section, as in I think it's easy, a little less trouble for the mind, and matters get sorted out quickly. So I think this is a section which is these days very popular for closing companies, especially which are net worth positive. Correct? So let
Yeah.
us look at this voluntary winding up section. Now, you somebody has approached you for the purpose of voluntary liquidation. Okay, so we will go through the entire process of from the time you are consulting the client till the time you are completing the matter in NCLT. I am not going to go through the voluntary liquidation process per se, but I am going to explain you the portion to the extent it deals with NCLT. Right? So, all right. So now you have been approached for a particular assignment on voluntary liquidation. Okay. The first thing that you will take from the client is the declaration of solvency and the balance sheets of the company, because they will have to give you the last 2 years balance sheet. You will have to see whether that solvency certificate is correct. And I am saying that because just recently in NCLT Chennai there has been an order which is passed where the court has said nothing doing, the declaration of solvency is incorrect, there was a debt in the company which was to be paid to director, so how did you say that you are solvent? So be extremely careful when you're taking up a voluntary liquidation matter, and where you are guiding the client deal with a voluntary liquidation matter, you will have to ensure that the company is net worth positive and it is able to pay all its debts. Only a solvent company will be able to go under section 59, and insolvent company will not be able to go under section 59. So before you take up the assignment, you will have to ensure that these conditions are fulfilled. Okay. So now you take up this matter, you complete the process under the voluntary liquidation. In this particular matter, you will have to take necessary documents from your corporate debtor, because it is a non adversarial type of a matter where the company themselves want to go into it. There is no question of non cooperation or anything. But when you file a section 59 matter, even in that case, many a times people forget to put a lot of things in section 59. Petitions for dissolution go on for several days, and therefore I am going to show you certain issues or certain things in drafting that you must see. So let's look at the just 1 second. Let's look at mm, the things that you need to see when you are dealing with a section 59 matter. There is the just 1 second. I will have yes. So I have just prepared a small checklist for you. Now you have completed the voluntary liquidation. You are going before the court under an application under section 59 to dissolve a company. So whenever you are going before the court, you first have to understand, because court is going to ask you questions. So you have to be ready. So in any
Madam,
say
can you share this format to us in the
sure,
chat box?
sure. I'll send, this is my personal format, but yes, definitely, no problem.
Yeah,
I'll
it
just
will be
have to
very
share.
helpful for all of us.
Yes. There are 2 3 things which are not added, which is that commencement certificate and all that has come. This is a little, this format has to include these 2 things which has come in later. Okay, that notices to all the authorities which has come in later, so I'll just deal with it. So now you are going before the court for dissolution. You have completed the voluntary liquidation process. You have liquidated all the assets which were there. You have put it in a separate bank account, voluntary liquidation account. You have paid the creditors who are there in the list of stakeholders. You have paid the stakeholders, the shareholders. You have paid the TDS amount. You have paid all the statutory liabilities, and now you have come before the court under a section 59 petition. Now first understand, before you start filing any application before the NCLT, what is the purpose behind filing the application. So when I'm dealing with a matter under section 59, I first have to see what is the purpose behind filing this application. So I will first go to the IBC law. I will not file the petition before I understand what is the purpose behind going under section 59 to NCLT. So I will first read what is section 59 say. Where is section 59? It has disappeared. Just 1 second. Give me 1 minute. I think it has gone way down.
You can say previous because it is upward, I think. No, it's
Yeah,
downward.
yes, I think it has gone way down. I have to
Yeah.
go to previous. So voluntary liquidation. First, I have to see what am I going to NCLT for under section 59. Section 59 says that for dissolving a company, it says that the provisions of 35. Just 1 second. I don't know. There's something. It's moving a little slowly. Give me 1 minute. Yeah. So, what are the sections which are applicable in terms of voluntary liquidation? See, this is the provision that says regulation 59. Just give me 1 minute, please. Yeah. So this is the section on section voluntary winding up. What does the law say in terms of regulation 7? It says when the affairs of the corporate debtor are completely wound up, its assets are completely liquidated, the liquidator shall make an application to the adjudicating authority for dissolution of the corporate persons. Correct? So what is the time when you can approach the court? You can approach after its assets are completely liquidated and the company is completely wound up. That means that you have completed the process of taking all the loans, taking liquidating all the assets. You have completed the process of paying all your creditors. You have completed the process of whatever formalities are like TDS deduction or some other payment or dividend. Earlier it was dividend distribution tax. Whatever payments have to be done, all those processes are completed and the company is completely liquidated. Okay, from the court's perspective, this is what the law says. Okay, plus what does the law say? For the liquidator shall make an application for dissolution of the corporate person. So this is an application which you file under section 59 subsection 7 for with respect to the adjudicating authority. Now you have to understand under which section should I file it. So one is section 59(7). The law says that you have to file this application. Dissolution as such is provided under section 54 also, so that section also needs to be seen to understand what needs to be done. You have to understand the court practices, because for instance, if you file a liquidation application, don't just go by. If you are dealing with that kind of matter, try to look at what the court how the courts deal with matters, because everything is online. So you can check the cause list, you can see if there is a section 59, you can look up those cases, because what kind of questions the court asks, it will help you to decide what documents you have to file in your 59 petition. Okay, so in NCLT Bombay, the court generally asks you a question that all right, you have wound up the company, but have you closed the bank accounts of the company? Now, there is no such provision provided, right? So that is a court craft or court practice. I'm just giving you an example when I am dealing with section 59. Because here we are dealing with not the law, but drafting, appearance, and dealing with matters in NCLT. So section 49, 59, one is a process which you will follow in voluntary liquidation process. But second is that you are going to court to liquidate a company. So please, and or to dissolve a company. So court has to give you an order that this company no longer exists. So for that, court is going to ask you question because they have to ensure that you have followed the process. All right. So generally in NCLT Mumbai, the question which court asks is whether you have closed the bank accounts of the company. So whenever you're dealing with a matter, you understand that what are the kind of questions that a court, which say for instance, if you have a matter in Ahmedabad, look at section 59s which are being dealt with Ahmedabad court. Look at what kind of questions are being asked there, which will give you a flavor of what you need to put in your section 9 petition. Okay. So first you will read this section, then you will go to NCLT. You will look at certain hearings where section 59 is being dealt with. In NCLT Bombay, if you are there, you will see that the court asks the question that whether your bank accounts are closed, right? So now you are ready to file your section 59 application. Now, before you file the section 59 application, what have you understood? That this is for dissolution. Company will be completely closed after that. You will be discharged as a liquidator. So when you are going to be discharged, you ultimately are going to get a clean chit from the court that nothing further needs to be done. So before any court gives you such kind of order saying that this company closed, liquidated, they are going to ask you questions. And therefore, in the section 59, you have to be ready to answer questions of the court. What are the kind of questions that the court may raise? That you have to think when you're preparing the application, when you're completing the process. So I'm just giving you certain questions that courts ask. For instance, what was the corporate debtor? When was it incorporated? What was the company doing? Because they sometimes are curious to know that why are you closing, why did the people want to close down the company? So they can ask you these kind of questions. Second, they want to understand whether this company was solvent when it went, because an insolvent company cannot go under 59. So if, say for instance, you have a bank loan, even if that bank doesn't put in that claim, say for instance, you have a 10 crore bank loan and you have assets of 5 crores. So there you will not be able to go under section 59. Even if the bank doesn't put their claim in the list of claims, you still cannot go for voluntary winding up. Why? Because section 59(3) clearly provides that you have to give declaration of solvency. So unless the company is solvent, it cannot go under section 59. Unless it is able to pay each and every of their debts, they will not be able to go under section 59. So if as a liquidator you are still appointed and you see that the company is not solvent, it is your duty as a resolution professional to point it out, because there can be complications if later on the court finds that there were certain debts, despite that there were certain contingent liabilities also, and despite that you have gone under this. I'll just give you an example. There was a company, and that company ultimately got liquidated, dissolved, because they kept that money aside. So there was a company, their actual liabilities were only say 5 crore rupees, but they had a notice which had come from income tax, and that notice provided that you have to, that there was a demand which was made on them, for which a case was going on, which was for 17 crores. So can you give that declaration of solvency? Because today the corporate debtor, the promoters will be very keen to close down the company under section 59, so that they don't have to go through the entire process of 7 and 9 and 10. They will be very keen. But can you as a liquidator accept such a kind of a section 59 petition? Company has assets of 5 crore. It has a liability of 3 crore. Say trade payables are 3 crore, but it has a contingent liability of 17 crores. Can you accept that as under section 59?
No.
According to me, this cannot be done, because declaration of solvency is required to be given, and you have to understand the true import of the declaration of solvency. And there have been cases where they have not understood and they have gone ahead, and there have been complications later on. Okay.
Sir, my query, ma'am, here,
Yes.
if we take with your example only, if the total net worth of the company is 5 crore and
Right.
the contingent liability is 50 lakhs only, for the sake of argument. And in that case, what happens? The demand has been raised and the appeal has been filed against that demand, but the appeal has not yet been decided. And the liquidation proceeding has been initiated based on the insolvency declaration.
Right.
So what should be done if the period taken by the appellate authority is longer? As a liquidator, what steps we should take? We should complete the process, kept the amount aside, or what action as a liquidator we should you will suggest?
In that case, firstly, whether you can go for voluntary liquidation or not, but definitely you can go for liquidation. There cannot be an argument that this 50 lakh can later on, if you don't pay, can be higher, because the law clearly provides that interest after commencement of section 59 will not be applicable. So therefore, you can rest assured that if CIRP the section 59 voluntary liquidation has commenced, there will be no interest. So that 50 lakh will continue to be 50 lakh. Correct? That is number one.
Yes.
So that debt amount can never increase. That debt amount is crystallized the moment commencement of voluntary liquidation takes place. So 50 lakh liability will remain 50 lakh. It can never increase and interest can never be put on that. Second, that proceeding, generally litigation continues for a very long time. So what to do? So in that case, firstly, can you file the application under voluntary liquidation? Can you start the process? Yes, because technically you are in a position, you have 5 crore rupees and your contingent liability is only 50 lakh. So yes, you can go under voluntary liquidation. Now, the second question is that what do I do? Do I wait till that income tax appeal is filed, then it will be heard, then it can take few years, then it can go to High Court, then it can go up to the Supreme Court. So what to do with respect to this voluntary liquidation process till that time? Correct?
Exactly.
That is the question. So now for this, you will have to go through the voluntary liquidation rules. And let me see if I have the voluntary liquidation rules. Because there is a provision in the voluntary liquidation rules that talks about what can you do, and that has been approved by the court in certain cases. Wait, because for everywhere, wherever you have a problem, you can go to the rules and regulations and see if there is a provision for your case, because many a times there are provisions in the law itself which you can take advantage of. Okay, so just 1 second. There is a provision in the law. I'm just 1 second. Let me just see if I can pull out that. So in the final report under section 38, there is a provision. Okay, that says that when you're giving your final report saying that the liquidation is completed, you can say that no litigation is pending against the corporate person, or you can say that sufficient provision has been made to meet the obligation arising out of any pending litigation. So there you find your answer, because you can prepare a final report even when there is a pending report. Otherwise, final report is the final. It is, as you can see, it is on completion of the liquidation process. Only then you can prepare your final report. So if the question is that can I finalize my final report even when there is a pending case, what is the answer? The answer is provided in regulation 38 itself. Regulation 38 says that look, sufficient provisions have to be met to fulfill the pending obligation. So you will have to keep that money aside, plus you will have to keep certain monies aside to deal with that litigation per se. And if you are able to convince the court that look, this litigation per se, the amount cannot be increased because interest cannot be charged, so this amount can never be higher than the amount which is currently in the contingent liability. Second, you will show that look, the entire amount of 50 lakh is deposited plus additional amount is deposited to deal with this litigation. So even if it comes, the matter will ultimately be dealt with properly. In that case, if you are able to convince the court, if you are able to show these provisions, then in that event, you will be able to liquidate the company by keeping this amount aside. Okay.
The second question arises, ma'am. When the petition of liquidation will be filed, that again the question of closure of the bank account will arise. So where to keep that amount aside?
see that in that event again, you might be able to take advantage of regulation rule 11.
Okay.
Because
Okay.
what has happened in one of the matters where this issue has arisen, what has been done is there is a provision to keep unclaimed dividends or unclaimed issues in that particular account of IEPF account.
But
So there,
nowadays there is clear-cut provision
um,
that it has to be transferred to the IBBI or something like that.
yes. So there the just one second. So there, that is what we had done was we had told the court that there is a provision to keep unclaimed amounts in a particular amount. This particular amount is right now unclaimed, so let it remain with IBBI. Once that amount is crystallized, then that can be paid to whoever. So that kind of order can be taken, and you can show that because the law provides for it, that you can prepare a final report even when there is a pending litigation, that should be allowed. And necessary directions, that prayer you can ask for in your in the prayers along with the prayer for dissolution of the company. But there, that time you will have to be careful regarding what kind of reliefs you are asking, that where this amount should be kept, who will be in charge of the account, who will deal with the litigation, because otherwise you will have to come back to the court for clarification. So that
That
care,
that is the guidance I needed from you, because
so that's
ultimately,
the
if
case
I take
specific.
that liberty on me as a liquidator, then I will be involved in the process till the disposal of the appeal,
Correct.
isn't it?
Correct. So, but this is a case specific thing. We can discuss it. But
Yeah.
I'm just telling you that as a liquidator, if you are faced with such a situation, you can go through the voluntary liquidation regulations, because
Sure. Sure.
they give a lot of clarity regarding what can and cannot be done.
Right. Right.
Okay, so this was just an example of how you can use the law and what kind of prayers. Then along with that, you have to think ki what type of prayer should I ask for, and then you will have to be a little futuristic to understand that okay, I will have a problem as who deal with the matter, I will have a problem where to keep this amount, I will have a problem because I can't keep the voluntary liquidation account open. That question the court will ask, so that requires a little bit of imagination. So even the smallest section like a section 59, which according to us we take it lightly, even this section requires certain imagination and certain times a little thought process before you get into it. And that's why I've taken this section, because uh, we going into one section 7 and 9, admission denial, all the case law landmark judgment, it will take forever. So therefore I thought let me explain you drafting from the perspective of the section which is regularly used by RPs. All right, are we clear on that? Should I go ahead?
Yeah. 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 Sure.
Yes. So now we are on the issue that I have completed my liquidation process. I want to go before the court. I want to dissolve the company. So you have to first imagine that if a responsibility is placed on you to decide everything is okay, dissolve the company, what will you do? You will ask whether the process is completed. You will ask whether the section 59 is appropriately initiated, because section 59, you do not require a court permission to initiate section 59. So therefore, the court is going to ask you whether 59 has been properly done. So therefore, he will ask you, the court will ask you, the courts can ask you, what is the corporate debtor, what is their background, what kind of business they were in, are they doing business or have they stopped doing business for the long time? That you can answer from looking at the balance sheet. These days, many judges are very conversant with the balance sheet, so they may ask you a question or two regarding balance sheet. So you have to remain prepared to answer whatever questions have been raised regarding balance sheet, right? Then they will ask you the process. That process prior to initiation of the section 59 is valid. So they will ask you whether special resolution was passed. Sometimes they ask you how many shareholders are there, how many shareholders have said yes, is the company a foreign company? So all these questions you have to prepare in advance, because what happens is today courts are overburdened. So your responsibility and my responsibility, as your responsibility as a resolution professional and my responsibility as an advocate, is to make the life of the court simple, because we also are officers of the court. We have to ensure that the process is speedy and smooth, and for that we have to ourselves remain so ready that the court doesn't have to adjourn the matter from one date to another. Because if you are not able to answer this question, court is going to give you a date. On the next date they will ask you certain other questions. If you are not able to answer those questions, and if those documents are not there in your section 59, again you will be given another date. And that way, an application which can take 10 minutes of time will get adjourned from date to date because you have not been able to answer the court. So your time will also be wasted, the court's time will also be wasted. So as an officer of the court, it is your responsibility to ensure that you give a holistic picture to the court, okay, in every application that you do, and that the court will appreciate you if you do that. The court will appreciate you if you are ready, if your all the documents are in order, and if you quickly deal with matters when there are some problematic matters in which there are complications, there are issues, that time the court will consider. If for smallest matters you take a lot of time of the court, then in other matters the court will say that no, you are never ready. Right. So therefore, as officers of the court, it is both our responsibility to ensure that we give a holistic picture. So, coming back, under section 759, you will have to show special resolution is passed. They will ask who has attended the special resolution. For instance, there are 20 members, only 5 have remained present. Have you given notices properly to them? In certain cases, it are small companies. For instance, whole subsidiary companies or wholly owned subsidiaries, only one shareholder, no difficulty there. But in other cases where there are larger companies, one of them, one or two of them object, then there can be complications. So in that event, the court may ask the resolution professional certain question. Minutes have to be given at times because minutes give that holistic understanding that what has happened in the special resolution. Because people what sometimes do is they just put that resolution one page. But when the court asks who was present, they are not able to answer. When the court asks how many people have agreed to it, they how many people have agreed to that decision, they are not able to answer. What is the percentage of voting? They are not able to answer. So in that case, if you simply put minutes of the meeting, you will be able to answer that. Just give me one. Sorry, some things in the court. I'm sorry. All right. So special resolution, intimation of special resolution to ROC in form MGT 14. Okay. This also you have to do so that you have to tell the court that the procedure regarding section 59 initiation was properly done. Now, what you must do generally in any matter is you should show the court under which section what has been done. For instance, as per the law, section 59(4), you have to intimate to ROC. So you should show the proof of intimation. Say a GNL2 has to be attached to show that look, I have intimated it to ROC. As per the law, you're also required to provide notice to IBBI. So whether an email or whether a speed post, when this has been sent, you have to show the court that look, I have intimated it to IBBI. This is the proof. So whenever you are dealing with any process, keep all the proofs ready. Because even in case of progress report, technically what the judge says, okay, progress report taken on record, matter is over. But at times court may ask you questions. So for that also you should be ready. So whenever there is a matter that requires compliance with certain sections, you should be ready with the backup, including the notices being sent, the proof of that notices being sent. Also keep, if it is a speedy post notice, also ask your office to take the tracking report, because later on if somebody asks you, you will not be able to do it. So as a matter of course, explain it to your office that whenever there is a speed post and get the tracking report and keep it, because that acknowledgement never comes. So that way, that small care if you take during the process, any process, later on you will be able to produce more proof. Okay. Then, now public announcement has to be given. Now, what happens is when a public announcement is given, you also give the court the proof that where is the public announcement mentioned. For instance, which newspaper, attach the newspaper of English newspaper, Marathi newspaper if you're from Bombay, or Hindi newspaper if you're from other cities. Then IBBI website, you have to show that look, on the IBBI website it is shown. Just showing it on IBBI website doesn't make sense because that notice doesn't show that it is on IBBI website. So have a print screen made of the IBBI website and show that look, the IBBI website, this is the notice and this is the ultimate notice which is placed on record. So that care you have to take to show that all the procedure regarding public announcement has to be made. Now, this I'm just giving you this example regarding income tax. In certain cases, this question was there, that whether you have to give notice to income tax during the section 59 process or not, right? So many people, as a matter of course, because in the old voluntary winding up section you needed an NOC from income tax. Only then under section 178, and I'm going to show you that 178, that how the law changes and how you have to deal with the that issue. Just 1 second, let me see if I have sections 178. Because when you're dealing with the section, you need to see what does the law provide. So section 178 of income tax rules, see, this was the old section 178 as per the Income Tax Act. Because you need to ask, because many a times earlier, now this issue is resolved, but I'm just giving you that example. That whenever section 59 were filed, court used to ask them that where is the no due certificate from income tax? Okay, what was the background behind asking this question? Because sometimes you have to understand that why is the court asking you a certain question. So this was in the background of section 178 of Income Tax Act, which was applicable to voluntary liquidation processes which were conducted under the Companies Act 1956. So what happened there was, under section 178, the income tax law provided that every person who is a liquidator of the company which is bound up under the orders of the court, they have to file an application. The assessing officer has they have to comply with the process, and it says that liquidator shall not, without the leave of chief commissioner or commissioner, part with any of the assets of the company or property unless he has notified the assessing officer. And thereafter, you had to give notice to them. You have to get the assessment regarding how much amount is payable, and only when they used to give you a no dues, only then you could close the company. Otherwise, you could not liquidate a company without taking an NOC under section 178. So it was in this background that the court used to ask you that have you complied with section 170. Now they don't ask, but earlier they used to ask. But I'm just saying that like this, other questions can also be asked. So you need to know what is the background and how do you convince the court that this particular aspect is not applicable. So how did you do that? So earlier when this issue came up, now right now there is a circular that says no dues is not required from income tax. That's the end of the matter. That circular, if you show it to the court will be convinced. But before that, what we had to show in certain section 59 matters was this, that section 247 of the IBC law says that income tax shall be amended in the manner specified in the third schedule. So we showed the court section 247 when they asked us for no dues certificate. All right, we told them that look, income tax law is amended by section 247. Now what is the amendment that is provided in the third schedule? What was the third schedule? Hmm. This is the third schedule. This is the third schedule of Amendment to Income Tax Act. What does it say? That under section 178, we have seen section 178 that says you have to take NOC from income tax before you wind up the company, whether it is voluntary winding up or whether it is a regular winding up. So in that, there was an amendment which was sought to be made by the IBC rules under section 247. 247 said that section 178, that was section 178 is amended, and therefore for time being in force, this word after that you have to add except the provisions of insolvency and bankruptcy code. Therefore section 178 of the income tax act was amended. They said that yes, NOC is required except when insolvency and bankruptcy code provisions are in play. So when section 59 is there, section 59 of IBC, voluntary liquidation takes place, it is a provision under the IBC code, and therefore section 188 is not applicable. So in light of that, there was a circular which was passed by IBBI that gave clarification that NOC and no due certificate from income tax is not required under the IBC code. And accordingly, they decided that right now you don't need to give NOC. So whenever you are dealing with any section, you can show the court that if you have not sent notice to income tax prior to this section 59 being done, right now they are asking you to inform in that clarification in that form G, come in uh, the completion certificate which you have to give, that I have sent notices to all authorities. So now again the provisions have changed. But when you are dealing with a particular matter at a particular time, voluntary liquidation regulations you have to follow. If at all there are certain questions like this question under section 178 came up, you should be in a position to answer the court that why have you not followed section 178. The answer is right now very clear under the notification, but you have to keep this notification ready because the court may ask you even today that.
But in practice, ma'am, we, for the sake of, just to respond to the, court, we normally sent at least a letter kind of thing to income tax authority as a matter of fact.
And you should, because what happens is earlier there was no provision, but today if
Yes.
you see, the law keeps on changing. So what you have to do is you have to follow the current norms. So if you see, there is a compliance certificate which has been attached now. This came in later. Earlier this was not there. You have to
Form
give
H or something.
Yeah.
Form H.
It's not showing. Just one second. So that form provides that you have.
That will come under voluntary liquidation regulation, ma'am.
Yes, but these are voluntary liquidation regulations.
Okay, then it should be there.
It's there. It's in the end. It's just that there's some.
Actually, this is
not moving.
I think at IBBI they have not replaced that. Still, I think there is some issue.
Not replaced, but I've seen it. Just one second. Hold on.
Okay.
I'll just show you. There's some problem. I don't know why it's not opening that fast. Some of the other problem with the technical problem with this. So this is that form G. So you have to give all these details that, and you have to give intimation to the statutory authorities. So therefore, now the law provides that you have to give notices to all the statutory authorities like PF, EPF, GST, all that. So as this form has been introduced, therefore now you have to ensure that you send notices to everybody. Earlier, you didn't have to send notices. You could have explained that 178 is not applicable. Now, with the provisions that that this is required, you will have to send them that notification. So what I am trying to say here is that the processes keep on changing because the voluntary liquidation regulations change. Then
Ma'am, if you want, you can take 5-10 minutes break in between.
yeah, okay, no problem.
All right.
I think we are almost done. I'm just trying to wrap it up because I want to show them the drafting of it, and thereafter I think we can close it for today. So
Sure.
I think there's something wrong. Let us leave it. So right now we again go back. Here we have to show that we have complied with it. Notices to income tax. I'm just giving you an example that how the law has evolved over time. Earlier, when 59 petitions were filed, the court started asking questions earlier, as in when it was a new regulations, court started asking questions that why didn't you comply with 178? Then there was a lot of discussion between why section 78 is not applicable. Then to just to be on the safer side, all the resolutions professionals started sending notices to income tax. Then the court started asking that, all right, you have sent the notice, but where is the no due certificate from income tax? And again, resolution professionals had to explain that, look, under 178, that no dues was required. Under the new regulation, it is not required. They were required to show that provisions of section 247 and the third schedule, by which this particular aspect was not required. Then when circular came up, that clarity was given, and then court, you, if you just showed the circular to the court would have been satisfied. All right, so such kind of issues, even if they are technical issues, your proceedings, your section 59 application may drag. And therefore, if you have this knowledge, and if you keep all these documents ready, or you give all these documents to your lawyer, he will be able to deal with this section 59 expeditiously. Because many a times the question is that, oh, my section 59 is dragging, the company is behind me, that why is the company not liquidated, it has been more than 2 years. So these things can be avoided if you are prepared. Okay, so now other thing is preliminary report. You attach that to your section 59 petition, so the court will see when did the liquidation process start, how many assets were there at that time, and all this basic information which the court may ask will be there in your preliminary report. Then you attach list of stakeholders. That is an extremely important which you have to attach, because you have to explain that whether you have received claims, whether you have not received claims. In many cases where voluntary liquidation takes place, at times this list of stakeholders shows that no, there are no stakeholders or there are no creditors, because generally companies close all the liabilities before they get into the voluntary liquidation process. But at times there are complications, because in certain cases there is dispute between the parties. I'll just give you an example, that we are closing a stock exchange in one of the matters. So in that matter, there are certain employees who have been paid, but they are raising the question today that no, we were supposed to be paid more. So they have filed their claims. RP has rejected it. They have filed an application under section 42 to say that, look, this amount, this is an additional amount that should be payable to me, and because of that, liquidation process gets uh, gets delayed. So that list of stakeholders is required to be produced to the court to show that, look, these are the list of stakeholders, all these stakeholders have been paid, and there is no other claim apart from this. This list of stakeholders, you have to basically, whenever you are filing an application, you have to show the procedure is complied with. So what does the procedure require under voluntary liquidation? That requires that it should be sent to IBBI. So therefore you also have to attach those proofs in the documents itself, so that your petition is so complete that your entire documentation is there. So tomorrow, if you just keep that documentation, you will be able to show any authority that, look, I have complied with the process. Okay, then final report, everybody attaches for final report to their liquidation, to their section 59. Along with that, you should also attach the proof of submitting it to IBBI, the proof of submitting it to ROC, because the voluntary liquidation regulations, regulation 38, require that. So you will have to show the court that that procedure is followed. Generally, when you have when you look at section 59 petitions which are being dealt with by the courts, you will also see that court will ask you for accounts. So that also is one document. Even if you have it, you should produce it in your section 59 petition. You should know what all documents are required, whether you're filing a section 7, section 9, or in this case a section 59. You should know that what are the important documents the court will ask. So anybody who has dealt with section 59, or if you see any hearing in NCLT, especially NCLT Mumbai, they will ask you for the final accounts, that what has ultimately happened to the money which you have realized. So this auditor certificate has the receipts and payments. If you are able to show that and say that this has been certified by the auditor, the court will be convinced that, all right, these are the payments and that entire amount has been paid. And finally, you attach the closure of bank account report. So this is one application. When you are filing, you prepare a checklist like this for every application or major applications that you have to file, so that you are prepared for NCLT. Okay, along with that, as I told you that in 59 now you also have to attach completion certificate, the completion certificate which shows that every procedure is completed. Okay. So that way you will be able to deal with the matter expeditiously if you add all these documents. And if you keep circulars that like this ready to answer any questions which have been raised by the court. If you keep all these documents ready, your voluntary liquidation process can get completed quickly. All right, and you will not face major troubles while dealing with any matter in the NCLT. So this is just a section 59 matter. Any other matter like 7 also, you should know what are the basic documents court will ask. What will the court ask you? They'll ask you for the financial contract. They'll ask you the proof of disbursement. They will ask you that show me the bank account proof that this amount has been disbursed. What is the date of default? Which is the document by which you have recalled the loan? What is the loan agreement? Is there some hypothecation or something? If it is a section 7 by the banker, they will ask you where is the what type of loan have you given? Have you given a working capital loan? Have you given a term loan? So all these things, whenever you're dealing with any type of section, look at certain orders which have been passed. For instance, any section 59 matter, if you see, step by step, the court has provided that this is the documents I have seen, and I am saying that now the matter is now the company is liquidated. So that will give you an understanding that at least these documents I have to attach. Apart from that, other documents to show process is complete I have to attach. Any section 7 petition, if you look at the orders, you will get an indication that all right, which are the documents the court will ask me. These 4 5 documents are referred in every order for admission under section 7. I have to produce this document. Similarly, in case of liquidation, section 33 petition, what is the document that court asks for? The minutes of the COC meeting, the notice of the COC meeting, how many COC members were there, what is the amount of voting, what have they voted. So all these things, if you attach it to that application, your application can be decided expeditiously, otherwise it will drag. Okay. Even in cases of resolution plan, sometimes they ask us where is the valuation report. They can ask, so at least keep it handy. You may not attach it because that is not required, but you can keep all these documents ready so that your matter gets decided quickly, because today everybody wants a early disposal of matter, and many a times they blame the authority, saying they blame the tribunal, saying that matters are not getting decided. But it is many a times our responsibility as professional to ensure that documentation is complete, the pleadings are complete in such a way that we are able to answer the questions which have been raised by the court. Because if you are able to do that, you will be able to get a quick disposal of your matter. Now, with this, we will come to the last part, which is the drafting. I am going to show you a draft which is there just to give you a flavor. Whenever there is a document which is being filed, you have to first write the tribunal where you are going to, then bench in the tribunal. For instance, in Mumbai, if it is bench 5 which is dealing with the matter, you write bench 5 and between Mumbai bench and company petition. If your matter is being dealt with by court 1, you write Mumbai bench 1, so that whenever your matter is filed, there is not too much of time taken to decide where the matter goes. In section 59, it is only a company petition, so it's a fresh petition. It can go to any court. So there you can't write which bench. But in other matters, for instance, section 33 petition, you know that wherever the company has been admitted, whichever bench, the same bench is going to deal with these matters. So you add that. Then, whenever you are dealing with any matter, you have to show the sections which are applicable. So, in our matter, what are the sections in voluntary liquidation? It is section 59. It is the insolvency board regulation, voluntary liquidation regulations which are applicable. If it is a section 33 petition, you put the liquidation section 33 of insolvency code along with whatever are the relevant rules which you have to see. If, say, for instance, it is a section 12A application, you add section 12A, you also add reference to regulation 30A. So what will happen at the time when the court is drafting the order, they will have a background regarding which are the sections which are under consideration, and that way any person can you take advantage of those two sections while considering your application. So whatever are the rules, regulations, whichever are applicable for any case that you are dealing with, you should include that. Any questions up till now?
No, ma'am.
Should I go on?
Yes, yes.
All right. So thereafter, you have to write the name of the company. I'm just not disclosing that name. It's in the public domain, so there's no problem because we as such share these documents on the screen in NCLT. But nevertheless, there's a dissolution of this particular company. This is the name of the petitioner. Who will be the petitioner? You will have to decide who will be the petitioner. For instance, I'll just give you an example. In a voluntary liquidation under Section 59, who files the petition? Liquidator, correct? Because he is the
Yes.
only person. But for instance, in section 27, who files the application? Is it the RP or is it the COC? Section 27 for replacement of RP. Who files the section? Who files the application?
That is COC.
Exactly. So many a time this issue had come up in a matter in Bombay High Court where they said that no, this section in one of the matters where they were asking for replacement of RP, they said no, this is not valid because this application has been filed by the IRP. IRP filed that application and this issue came up. In another matter which was there, that was section 12A. Who filed section 12A application?
But after the various court judgment, now even apart from the applicant, there are other person are also allowed to file the application.
Which application? Every application you have to decide who can be the petitioner, correct? Section 7 and 9, it's a no-brainer. It has to be filed by the financial creditor. Or if it is a debenture holder, then it has to be filed by the trustee. That person will be the petitioner. But for instance, section 27, who will file it? It will be filed by the COC. So many a times it happens that accidentally RP files it and the promoter being who is, he can challenge it, saying that no, this application is invalid. So the financial creditor can get trouble, ultimately the wrath will come on the resolution professional that why didn't you tell me it is the COC who has to file. So I'm just giving you an example where unnecessarily that has been the reason for the delay. Okay.
Like in this current case, you see in Srei, the promoter has filed the application for the settlement.
Under section 12,
Under 12A, 12A, 12A
correct.
for settlement.
I'll give you an example of 12A.
Yeah.
12A, the law provides that it is the resolution professional who will file it or the IRP who will file it while the 12A application, right? But there have been times where the RP is not ready to file. In that case, the promoters or the financial creditor themselves file. They explain it to the court that look, we want to settle the matter. The RP is not filing the application, and therefore it is just an equitable that this application may be considered. So in such a case, they can file that application under section 12A. Okay. And under rule 11, it is an inherent power of the court to consider that injustice should not be done. So if the RP, though it is his responsibility to file the application, has avoided it or delayed it or is not ready to file it, or he is saying that no expression of interest is already given, so I cannot now file a 12A application. In such cases, they can explain to the court that this is the reason for the RP not filing it, and therefore we are filing it. So that application will provide explanation regarding why it is not being filed by a particular person. Okay. So I'll give you one more example. There have been cases in NCLT Mumbai where the avoidance application has been filed by the COC. Why? Because COC said RP has not put forth these issues. So it is our responsibility as COC. It is our inherent right that we have to recover this money from the promoters. So we are filing this application. So there have been cases that apart from the person who is mentioned in the rules, other person may file the application. And in that event, you will have to give the explanation that why has this application not been filed by the person who as per the law is required to file it. Okay. Are we clear on that?
Yes.
Yes. So now, whenever you are preparing a petition, every court has a particular style in which the documents have to be prepared. All right. And that particular style can change from time to time. All right. So if you are filing a petition in Bombay, you will have to produce a list of dates. You will have to prepare a synopsis. You will have to prepare a memorandum of parties. You will have to prepare the petition, affidavit of support, wakalatnama. If you are giving the matter to be argued by somebody else, wakalatnama. So that way you will have to follow certain processes. So similarly, whenever you are filing any application before any NCLT, there are certain things which may differ. So those certain things you have to take care. For instance, in Bombay, you have to file on one-sided green ledger paper. However, if you are going to NCLAT, the manner in which the documentation is to be prepared is different. So whenever you are either filing a petition here or you are filing an appeal in NCLAT, always ask the person who is dealing with that particular code regarding which manner do you want this particular documentation to be prepared, or else you can simply go to NCLT, NCLAT website. For instance, in NCLAT, if you want to see what is the manner, you can simply go to the NCLAT website. There are court notices that says that this has to be done in a particular manner, circulars, orders, vacancy. They just one second. There are certain procedures per caveat. What is the procedure? What is the filing? What are the type of objection that are raised? So this, what is the amount of fees that are to be paid? All these documentation. What is the notice and procedure for filing? What steps have to be taken? So all these things are provided in the particular tribunal's website. So either you can talk to somebody there who is already filing petitions there, or else you can look at the standard drafts which have been given by them regarding what steps are to be followed. Okay, that will give you a understanding as to how to do it. For instance, now if you want to attend physical hearing in NCLAT, what is the manner of attending the website, attending the matter? It is given here. Earlier it was allowed. What is the manner of taking inspection of record? It is given in the this. So if you take a look at these, you will get the checklist for appeals. For instance, you want to file an appeal, you will get the checklist for filing. Okay, so that way you can check the checklist every time, because there is no standard answer. Today there might be one process which is followed. Tomorrow the court, for the sake of convenience, can change what it requires. Okay, so that way you have to check. We have already seen what are the type of documentation that have to be done in a particular matter, right? So here you will give an index giving all the documents which you have given, so that at one glance court is able to see what type of documents have been filed. If you are appearing in person, you don't have to give wakalatnama. If a company secretary is appearing for you, you give memorandum of appearance. If an advocate is appearing for you, you give wakalatnama. Then you start with the actual process where you give them the list of dates. This list of dates is relevant. You put the details of everything so that at one glance, court is able to see the synopsis that every procedure has been followed. Okay. Then memorandum of parties is required as to who exactly are the parties, right? Then you go to the main petition draft. There is a now 100 rupee stamp paper and all these formalities are required to be completed. So you should always check whether the formalities like a 100 rupee draft and everything is prepared. Okay. Then you come to the actual petition where you mention what is the jurisdiction, whether the petition has been filed in time, and that also you have to see whether it is filed in time. Then what are the incorporation details, what are the main objects. So you give a background regarding the matter, so that the court generally will hear you out, and then they will reserve the matters for order. So therefore, what you should do is, in your petition, it has to be significantly detailed to ensure that you give them that entire perspective of what all procedure you have complied with. So even if the hearing say takes place in 5 minutes and your matter is reserved, and after 10 days the order is taken up for being for being prepared. So in that case, the court will be able to see the details in your petition that you have followed the entire procedure. So not just the documentation has to be attached, but a detail has to be given regarding what has been done. All right. So this is about drafting of the petition. This is for section 59 where entire thing has been given. As I told you, you have to ask for appropriate reliefs. Prayers are the most important thing in any petition or application that you draft. Sometimes wrong prayers can create a lot of complication. So therefore, it's section 59, fairly simplistic. Dissolve the company, But as we have seen that if there are pending litigation, you will have to ask the court for the permission for certain reliefs that allow that amount to be kept in a separate bank account, how this matter has to be arranged. So your prayers have to be appropriately drafted in every case. So I think with this, I think we can close for today. If there are any questions, you can ask me, and I'll endeavor to answer it. Just stop screen sharing. We can just have a quick discussion regarding it. Yes, please.
Almost everything you have tried to cover in your presentation, basically, and we have already interacted in between also.
Okay, so with this, see what happens is IBC, NCLT, it's a very large field, so you will not be able to cover everything. But what we can do is we can understand the flavor regarding the complexities that we have to take care when we are dealing with any NCLT matter. So we have seen regarding just one section, which according to me is the smallest section, section 59. But rest of the section, like section 30, when you're dealing with the resolution plan, you have to understand that what all I should add. Because it should not happen that because you did not mention anything, affidavit after affidavit is required to be filed. Clarification after clarification is required to be given. Because then the financial creditor, because as an RP, you have to deal as an RP and as a liquidator, you have to deal with multiple people. You're considered like a god. Everybody is on to you, asking you ki, why didn't you do this, why didn't you put this, why didn't you put that. So therefore, as an RP, you have to take extreme care when you're filing such kind of things, so that all the parties and all the issues which you have seen, or any issue which you feel, all those should be raised in your petition itself, so that the court is aware regarding what exactly is your actual case about. Okay, like even in 33, if there is some complication, some main financial creditor who has not come, who has later on written to you that no, I want to, right now I'm withdrawing my approval for liquidation because some resolution plan has come later on, you give those details, so that tomorrow the court will not tell you, "Ki, why haven't you informed me this?" If the financial creditor comes and challenges that section 33, or if the if the promoter comes and challenges that 33. So that way, in every application, have the foresight to see what kind of questions can be raised, have the foresight to put relevant documents. You don't need to put everything, because if you put all the documents which you have done in the section 59, and your section 59 is five different volumes, 1,000 pages, the court is going to say, oh my god, I have to look at a lot of things, we will see it some other day. It is not a 10-minute thing. So it is a fine balance of what to put, what not to put, all the information, how you present it to the court, relevant information, not irrelevant information. So that for every section, you will have to decide that what is the relevant information I have to put, how do I put it, what is the format I have to put it in. Okay. With this, I think we have completed drafting, pleading, appearance. In appearance, I will just say 2 or 3 points: that be courteous to the court, be prepared, because court generally asks liquidator and resolution professional certain questions which may not be dealing with that particular thing. For instance, you go with a progress report saying that uh, some process has been completed. Court can ask you that, okay, in liquidation you have put a progress report, how many properties have remained, why have they remained, how many auctions have been taken place, why have the auctions failed, which newspaper have you put the auctions in. So many a times what happens is, progress report, many people feel we just put the progress report, court will accept it, move on. That sometimes may not happen. So as a liquidator and as a resolution professional, be prepared that if certain questions come before the hearing, because you are a resolution professional, you know everything, just that you have to just brush up your memory before you go before the tribunal. Because as a resolution professional, there's an enormous responsibility cast on you. Court also understands that, and they want to sometimes understand the entirety of the process. So even if that application is regarding something else, they might ask you certain question regarding the process. So overall, have knowledge of the process when you are going before the court. With this, I think we can close the matter for today. We have dealt with the drafting, pleading, appearance. I have given you certain examples. If you have any further question, please feel free to write to me. I am also there on LinkedIn, so you can raise your questions there. And of course, you can raise it before ICSI, IIP, because I think they are very proactive in putting FAQs and answers. So I think the institute also at times gives a lot of clarity and puts forth the issues of the RPs and the liquidator before the regulators. So I think they are doing a wonderful job there. And with this, I think I'll close the session for today. Thank you very much for a patient hearing. I understand 3 hours is a very long time, but thank you so much for listening in.
Thank you, ma'am. Excellent deliberation. Thank you.
Thank
Ma'am,
you.
on the behalf of
This was a nice
ICSI, I would like to thank you for this detailed presentation on the on NCLT and NCLATs. Thank you so much, ma'am. I hope that all the participants will learn a lot from this presentation, and you did absolute justice to the topic. Thanks a lot, ma'am, for taking out time for today's session.
Thank you. It's my pleasure.
Wishing
Thank
you a very happy International Women's Day, ma'am.
Thank you so much.
Thank you, and thanks to all the participants. Thank you so much.
Thank you. Good day.
Good day, ma'am.
Happy Holi in advance.
Yes, same to you, ma'am.
Yes.
And I will be sharing the PPTs once I'll receive it from ma'am. I will share it, and I have also coordinated with the previous speaker. So I hope she will be sharing it by today or tomorrow. Then I'll share both the PPTs over mail. Thank you.